covered general award. The 29 general award. ನಾಳೆ ಆಯ್ತು. ಸರ್ ಇದು ಓಲ್ಡ್ ಮ್ಯಾಟ್ರ್ ಕವರ್ಡ್ ಇಶ್ಯೂ. ಓಕೆ, ಒಂದು ಹೊಸದಿದೆ ಬಟ್ FR ನಂಬರ್ ಬರ್ಬೇಕು. ಈ ನಂಬರ್ ಜೊತೆ ಕೊಡ್ಬೋದಲ್ಲ ಫೈಲಿಂಗ್?
Indulgence, my lord. My lord, during the pendency of an appeal before the Commissioner of Tax, my lord, a communication is issued to my banker and thereby my bank accounts have been frozen, my lord. As far as we understand, the appeal is still pending and there is no communication of that order yet, my lord. There is a freeze on my bank accounts, my lord. I am a company operating with aerospace engineering, my lord. Today I am literally crippled, my lord, because of this freeze. May I be permitted to?
Tomorrow.
Please, my lord.
You ask the other side to take instruction.
Please, I will.
In writing, you communicate.
Grateful.
Could he could. Okay, but how does it come before me? You just give the memo. Fine. Tomorrow, let us see. Let us see. You ask, give it to fresh matter.
Pending.
In the I'll find out. At 1:30 you meet the 2:30 you meet the court officer.
Your lordships, your lordships.
Fresh matter. Put it. Pending. Who's the authority? But you must inform them. I'll take it at 2:30. Correct. But now you inform them that you have moved it, it will come because they have to be notified. Come on, 2:30. Yes. But it's your responsibility to have the office objections cleared and the file. Fresh matter. Special bench.
Yes.
Give it.
The RWA, Resident Welfare Association, not liable to service tax. That is not reaching. Any posted for a fresh.
So,
This is a matter.
preliminary hearing is still.
This is a matter pertaining to acquisition, my lord. It's covered by the judgment that issued the notification for the converted property, my lord.
So,
Covered by the judgment.
Monday.
The pending matter. Allotment to the association society was made in 2000. After 25 years, they still don't give the land to the society. Now, my lord, the members of the society for whom the land was supposed to be are retiring, few of them have passed away. I mean, your lordship stands any date.
Good.
26 years we have.
Your lordships, tax related matter, your lordships, an ex parte order has been passed against me. I am unaware of the same and my bank account has been freezed, your lordships. At that instance, I've got to know that my bank account has freezed. Urgency, your lordships. May kindly have it tomorrow. Fresh matter.
Lordship, BDI had
Tomorrow.
Let us see tomorrow or Friday.
pending matter, your lordship. BDI had allotted land to me, and it is also allotted the same land to the subsequent purchaser. And now they are constructing in that particular property, your
Give
lordship.
it.
If it can be kindly posted tomorrow, your lords.
No.
My
Please.
lord,
Tomorrow special roster. Tomorrow special roster. We'll see. Tomorrow or day after tomorrow.
It's a pending matter, my lord. This is the third round of litigation.
Give it,
My lord,
give it.
We have filed the objections also. Readings have completed. My lord, they have taken, means by misleading the coordinate bench, they have taken stay. Kindly take up this matter Friday or Monday,
Date no.
please.
my lord,
BDI matter, my lords.
Give
my
it.
lord, this is a fresh.
Fresh matter.
Yes, madam.
Give it.
This is disposed matter seeking modification of the order. 6 weeks time was granted. We want an extension.
Give it.
This is pending big
Thank you.
matter. Kindly investigate it.
Give it. Preliminary hearing.
My lords, this is a fresh matter. The respondents have initiated recovery on GST demand and duty-free shops.
Give it.
listed tomorrow, request that will be listed tomorrow, my lord.
My lords, fresh matter. Accounts already been attached. If my lords could briefly indulge today, end of the list.
Not today.
My lords, tomorrow I am afraid I would have not, I'll not have the same case to be made.
What is the,
My lords, it's a 74 notice, unreasoned, entirely unreasoned. Order has been passed. They have attached the accounts and we have discharged the tax liability bona fide. So it's only on the penalty, my lords. Now, if they take the penalty, then I am denuded of my benefit that I can claim under the amnesty scheme. So a brief indulgence,
yes, madam.
fresh matter.
Central-
Fresh
central
matter,
or-
my lords.
Central or state?
Center, my lords.
When you tell Arvind,
Arvind, sir.
you see if you can take notice in that matter. You find out and get some instructions. He wants it today itself. Some at, correct?
I shall, my lords.
But give it.
Is paying for a parole.
Parole, how does it come before this court?
Last time your lordship.
No. At
10 minutes, list one.
last time the roster is over.
List
You have
one,
to
page
go
number
before the
1,
GM roster. Yes.
1 to 5, page number 2, 6 to 11, page number 3, 12 to 15, page number 4, 16 to 19, page number 5, 20 to 25, page number 6, 26 to 31.
My lord, serial number 26, my lord. In that, there are other two writ petitions pending which are emanating from the same impugned notice, my lord. I request my lord that all these matters may be taken up together. I am giving the writ petition numbers.
List along with so and so. Date.
Serial number 27, my lord.
You inform the,
Interim order may be extended, my lord.
inform the other side.
Yes, ma'am. Definitely.
Interim order and operation extended to next day.
Serial number 27, my lord. Appearing for respondent number 2. Seeks 2 weeks time to file objections, my lord. Statement of objection.
But have you informed the
I
other
have
side?
informed the other side, petitioner counsel.
Your other colleagues of the respondent also, your duty to inform. Relist date.
List one.
After 2 weeks. After 2.
Kindly, my lord. List one, serial number 28. For respondent, my lord, I informed the petitioner. Please 2 weeks time to file.
That request list after 2 weeks.
Much obliged.
List 2, page number 1, 1 to 4, page number 2, 5 to 12, page number 3, 13 to 19,
17.
page number 4, 20 to 27, page number 5, 28 to 32, page number 6, 33 to 38, page number 7, 39, page number 8, 40 and 41, page number 9, 42 to 46, page number 10, 47 to 51.
My lord, serial number 48, my lord. My lord, actually there is certain developments in the case, my lord, after filing the writ petition. Therefore, my lord, a short date may be given and the matter may be adjourned.
Inform the other side.
Please, my lord.
At request. Relist week after next.
Much obliged.
Page number 11, 52 to 55, page number 12, 56.
With my lord's permission,
70.
if I may mention a matter that's there on today's, my lord's list 252. My lords, it was listed yesterday as well, but matter was passed over, my lords, at 4, and then, my lords, it did not reach. My lord, there's a need for an interim order in this because, my lord, the matter is before the Commissioner of Service Tax on Friday. And, my lord, there are threats that the Commissioner will proceed with the matter. My lord, this is in respect of incidents of service tax on works contract.
I'll make a note.
Please.
At 2:30, you inform the court officer, please.
Please. Much obliged.
List 2, fresh matters. Serial number 1, Manoj SN. Dilip.
147 order has been challenged. It's party order, page 23.
Yes.
Because the notices were not served upon me. In my absence, the order has been passed. The operative portion is at page 25 notes.
Page?
25. Para 4.5.1. In my absence,
what was the reason for not?
Because the copy was not served upon me. My auditor in the last moment, he has sought for an adjournment, but it has been rejected. Even if it's remanded to the stage of show cause notice, my lords, I can provide the documents. My lords, this is a case where, my lords, I purchased liquor to the sum of rupees 2 crore 57 lakhs in the year 1920. I have shown sales of 1 crore and inventory of 45 lakhs. With respect to the remaining 1 crore, has been treated as sales, and at the rate of 8%, profit has been calculated at 8 lakhs, and penalty has been imposed to the 100%, and 16 lakhs order has been passed.
The analysis is there at page 22 in the assessment of.
And after adjusting my TDS and other returns, they have passed in computation sheet for a sum of rupees 5 lakhs. Even if it is remanded, my lord, that if a fine is imposed on bona fide.
Can be remanded to the stage of 148 notice so that let him file a return. If you not filed it.
If I am not fine. Not a necessity.
Petitioner has called in question the correctness of the assessment order at annexure A passed under 147, read with section 144 and 144 capital B of the Income Tax Act for the assessment year 2018-19, comma. Petitioner has also challenged the demand notice at annexure B, computation order at annexure C, and further proceedings. In the case of the petitioner, the petitioner did not file a return in response to the notice under 148. Tirumalesh. It's the case of the petitioner that he did not file a return in response to the 148 notice.
He has not filed a return, though he is asking for 142 notice, it can be sent, but then there will be a problem of not filing return. Let it go back to the 148 notice, let him file a return within a period of 2 weeks or 3 weeks. Then the process will start.
It's the further case of the petitioner that he did not make a reply to the show cause notice as the same was not served. It was not served, is it? It was not served.
It was not served.
Same was not served.
They have filed a response.
Huh?
Only 148 was served, my lord. Subsequently, the other notices.
Subsequent notice, they have filed a part response.
Though the 148 notice was served, the subsequent notices were not served. It is a case of the petitioner that insofar as the variation is concerned, he has an explanation to offer and accordingly seeks that the matter be remanded with fresh opportunity. In light of the case made out and noticing that the order is passed on the principle of best judgment assessment and has proceeded without any stand appropriate to remit the matter back to the stage of filing of return in response to 148 notice. All contentions are kept open. Accordingly, now what has to be set? What has to be set aside?
Set aside as a year enclose only annexure A, that assessment order, that has to be set aside.
Accordingly, the assessment order at annexure A is set aside, as also the consequential demand notice at annexure B, computation sheet at annexure C, and consequential proceedings pursuant to annexure A. Petitioner to file return within
in response to the notice under section
within a period of
3 weeks.
3 weeks from date of receipt of certified copy of the order. All contentions are kept open. Yes.
And name may be shown.
Serial number 2, M. Kumar.
I appear for the respondent, my lord. I will take notice, my lord. The first appellate
Yes,
authority is held under section 129 penalty, my lord.
The GP accepts notice for second respondent. So what, you have to take some stand, is it?
Yes, my lord, because there is a violation after expiry of
Only
e-way
one
bill.
agreement.
They are as per rules, rule 138A of the CGST Act.
And commission.
They are supposed to generate extension of time. They are
List.
not filed. Hence, the first appellate authority rightly passed an order
List after 2 weeks.
after 2 weeks, my lord.
Yes.
3. Badri R. Pradeep Kumar.
I pay for petition regarding acquisition of the lands, but it's a land regarding acquisition of the land has been covered by judgment of the Sample Court. I kindly look into page number. Page number 127, annexure, yes. Regarding acquisition, I will leave off. I only have sought for the mandamus where the land is acquired in respect of survey number
120.
Page number 127. The operative position at page number 180.
One.
180. Page number 181, class 8, Manu.
What is?
Lord, I have submitted a memo.
I'll
Lord.
submit, I'll submit.
Before that, Lord, I
I'll
don't want to waste Lord's time. Lord, I have submitted a memo, Lord, which says that Lord, his land is not at all acquired. We are categorically saying that Lord, his land is not acquired. I don't know why he is challenging the acquisition person. I have submitted a memo along with Lord, an endorsement issued to him.
Where is that memo?
Monne court office. Page number 1, Lord, to the memo. Imbaraha.
Yes.
Lord, ಮೇಲ್ಕಂಡ ವಿಷಯ ಮತ್ತು ಉಲ್ಲೇಖಗಳಿಗೆ ಸಂಬಂಧಿಸಿದ ಬೆಂಗಳೂರು ಜಿಲ್ಲೆ ಆನೇಕಲ್ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಬಗ್ಗನದೊಡ್ಡಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 96 1 ಎಕರೆ ಜಮೀನು ವಿಸ್ತೀರ್ಣ ಜಮೀನಿಗೆ ಸರ್ಕಾರದ ಆದೇಶದಂತೆ 50-50 ಅನುಪಾತದಲ್ಲಿ ಅಭಿವೃದ್ಧಿಪಡಿಸಿದ ನಿವೇಶನಗಳು ಕೋರಿರುವುದರ ಉಲ್ಲೇಖ 2ರಂತೆ ನಿಮ್ಮ ಜಮೀನನ್ನು ಬಾಬ್ತು ಮಂಜೂರಿ ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಅಳತೆ ಮಾಡಿ ನಕ್ಷೆ ತಯಾರಿಸಿ ವರದಿ ನೀಡಲು ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯಕ ನಿರ್ದೇಶಕರಿಗೆ ಪತ್ರ ಬರೆಯಲಾಗಿತ್ತು. ಉಲ್ಲೇಖ 3ರಂತೆ ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯ ನಿರ್ದೇಶಕರು ಸರ್ವೆ ಮತ್ತು ಕಂದಾಯ ಮಂಜೂರಿ ದಾಖಲೆ ಪರಿಶೀಲಿಸಿ ತಾವು ಅನುಭವ ಇರುವುದಾಗಿ ತೋರಿಸಿರುವ ಪ್ರದೇಶದ ಕರ್ನಾಟಕ ಗೃಹ ಮಂಡಳಿಯ ಸ್ವಾಧೀನದಲ್ಲಿದ್ದು ತಾವು ಅನುಭವ ಇದ್ದ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲಾತಿಗಳು ಕಂಡು ಬರುವುದಿಲ್ಲ ಹಾಗೂ ಸರ್ಕಾರಿ ಜಮೀನು ಅಳತೆಯ ನಕ್ಷೆಯಂತೆಯೂ ಸಹ ತಮ್ಮ ಅನುಭವ ಪ್ರದೇಶದ ಬ್ಲಾಕ್ 36A ರಲ್ಲಿರುವುದಾಗಿ ನಮೂದಿಸಿದ್ದು ಸದರಿ ಬ್ಲಾಕ್ 36A ಮಂಡಳಿಯ ಭೂ ಸ್ವಾಧೀನಗೊಂಡಿರುವ ಜಮೀನಲ್ಲಿ ಇರುವುದಿಲ್ಲವೆಂದು ನಕ್ಷೆ ತಯಾರಿಸಲು ಸಹ ರಹ ಇರುವುದಿಲ್ಲ ಎಂದು ವರದಿ ನೀಡಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ತಮ್ಮ ಪರಿಹಾರ ಕೋರಿ ಸಲ್ಲಿಸುವ ಅರ್ಜಿ ವಿಲೆ ಮಾಡಲಾಗಿದೆ. This land is not at all
36A.
Yeah, this land is Malad, we are not acquired.
His claim is for 36A.
Okay.
And your stand
He is stated to be in Malad possession of Malad 36A. Lord, the ADLR, Lord, drawn a master. Lord, kindly take page number 4, Malords.
Yes.
ಬೆಂಗಳೂರು ನಗರದ ಜಿಲ್ಲೆ ಆನೇಕಲ್ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಬಗ್ಗನದೊಡ್ಡಿ ಗ್ರಾಮದಲ್ಲಿ ಗ್ರಾಮಸ್ಥರ ಕರ್ನಾಟಕ ಗೃಹ ಮಂಡಳಿ ಅಧಿಕಾರಿ ಹಾಗೂ ಭೂಮಾಪಕರ ಸಮಕ್ಷ ಹೇಳಿ ಬರೆಸಿರುವ ಮಾಜರ್ ಏನೆಂದರೆ ಆನೇಕಲ್ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಬಗ್ಗನದೊಡ್ಡಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 96 P188 ಪೈಕಿ 1 ಎಕರೆ ಜಮೀನು ಬಾಬ್ತು ಅಳತೆ ಮಾಡಿ ಆ ನಕ್ಷೆ ನೀಡಲು ನಿಯೋಜಿಸಿದಂತೆ ಕಚೇರಿಯ ಜ್ಞಾಪನಾ ಸಂಖ್ಯೆ ಸೋನ್ಸೋರ್ ಆದೇಶದಂತೆ RTCಗಳನ್ನು ಮತ್ತು ಗೃಹ ಮಂಡಳಿಯ ಅಧಿಕಾರಿಗಳಿಗೆ ಗುರುತಾಗಿ ತಿಳಿಸುವ ನೀಡಿ ಸದರಿ ದಿನಾಂಕದಂದು 24/10/2025 ಸ್ಥಳಕ್ಕೆ ಹಾಜರಾಗಿ ಅರ್ಜಿದಾರರು ಹಾಗೂ ಗೃಹ ಮಂಡಳಿಯವರ ಅಧಿಕಾರಿಗಳ ಸಕ್ಷಮ ಕಂದಾಯ ದಾಖಲಾತಿಗಳಂತೆ ಅಳತೆ ಮಾಡಲಾಗಿ ಅರ್ಜಿದಾರ ತೋರಿಸುವ ಅನುಭವ ಕರ್ನಾಟಕ ಗೃಹ ಮಂಡಳಿಯವರ ಮಣ್ಣು ತುಂಬಿ ಸ್ವಾಧೀನವಾಗಿರುವ ಕಂಡು ಬರುತ್ತದೆ. ಮಂಜೂರುದಾರರ ಕಂದಾಯ ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಅರ್ಜಿದಾರರಿಗೆ ಮಂಜೂರಾಗಿರುವ ಬಾಬ್ತು ಕರ್ನಾಟಕ ಗೃಹ ಮಂಡಳಿ ಭೂ ಸ್ವಾಧೀನಪಡಿಸಿಕೊಂಡಿರುವುದು 36 ಎಕರೆ ವಿಸ್ತೀರ್ಣಕ್ಕೆ ಕರ್ನಾಟಕ ಗೃಹ ಮಂಡಳಿಯು ಸ್ವಾಧೀನಪಡಿಸಿಕೊಂಡಿರುವುದು ವಿಸ್ತೀರ್ಣದಲ್ಲಿ ಇರುವುದಿಲ್ಲ. ಎಂದು ಭೂಮಾಪಕರು ತಿಳಿಸಿ ಅರ್ಜಿದಾರರು ಈ ಬಗ್ಗೆ ಸ್ಥಳಗಳನ್ನು ತಕರಾರು ತೆಗೆದು ಈ ಹಿಂದೆ ನಾವೇ ಅನುಭವ ಇದ್ದು ತಿಳಿಸಿರ್ತಾರೆ. ಆದರೆ ಕಂದಾಯ ದಾಖಲಾತಿಗಳಂತೆ ಅರ್ಜಿದಾರ ಅನುಭವ ಇರುವುದು ಸದರಿ ಪ್ರದೇಶ ಇಲ್ಲದಿರುವುದು ಕಾರಣ ನಕ್ಷೆ ತಯಾರಿಸಲು ಅರ್ಹ ಇರುವುದಿಲ್ಲ ಎಂದು ತಿಳಿಸಿದ್ದಾಗಿ ಅರ್ಜಿದಾರರು ಹಾಜರು ಮಾಡಿ. This land is not at all acquired.
Survey number 96 is a huge extent of 900 acres is a Gomara Jamin and forest area is also there. Where the correspondent is acquired for the housing purpose only for 36 acres. I am within the 36 acres.
They are saying no.
No, he is saying, for example, the kindly look to page number annexure J, page 96.
No, correct. So that you ask for a survey by the
Tahsildar.
Revenue Department.
Lord, is done by Revenue Department. ADLR.
As per
Survey is done by
section 140 of Land Revenue Act, where the boundaries are.
Correct, but what is your prayer in the present petition?
Only to consider mandamus to consider my representation to identify the land.
No, correct. That on the
Page number 28, prayer 3.
Whether housing board can do that, my lord, that is the question. My lord, if they, my lord, file a case against, my lord, Revenue Department, that is, my lord, you
must
can't
only
ask
seek
the
for-
mandamus against, my lord.
Correct. You seek against relief against the Revenue Department, they will do it.
Lord, in fact, my
Where
lord,
is
this measure was drawn by, my lord, pursuant to letter written by, my lord, the housing board, my lord, to ADLR. This measure was drawn, my lord, in the presence of the petitioner as well as, my lord, the officers.
File a separate writ, then the Revenue Department, make the Revenue Department a party. You make your allegation that according to you, you are in possession, etc. Let them take their stand, we'll pass some more.
My prayer is, may kindly look into my prayer number 20.
ADLR is given. Lord, it is, my lord, vast extent of land. My lord, survey number 96, my lord, consists, my lord,
they are
950
claiming
acres
only
of land.
36.
No, at the most, you want the government advocate to take their stand, I'll ask them to take this.
Yes.
You take a stand in writing. I'll give you 2 weeks' time. I'll notice there what they've said. You take your stand in writing. The Land Council H.L. Pradeep Kumar appearing for the Karnataka Housing Board submits that the plea of the petitioner cannot be considered. The plea of the petitioner as regards grant of developed land as compensation.
In lieu of monetary compensation.
In lieu of cash compensation cannot be considered in light of the property of the petitioner in block number 36A being outside the acquired area. Reliance is placed on the endorsement of 6/1/2026 filed by the Housing Board along with the memo dated 20th January 26. Third counsel for the petitioner would submit that the survey number
96.
96.
Bagganadoddi village.
96 bar P 188.
The counsel for the petitioner, on the other hand, would contend that the property of the petitioner falls within the acquired area. In light of the stand by counsel for Housing Board, and the reliance placed on documents of Revenue Department.
And also Mazar, my lord.
And
drawn by-
Mazar, government advocate to take their stand in writing within 10 days, relist week after next.
The same, my lord, category. Same category. Fresh matter.
And the same stage.
4, Pradyumna.
Any date may be fixed.
Preliminary hearing. Preliminary hearing.
I appear for the response.
In this matter, proceedings were initiated by the department against the petitioner for under declaring and reporting of tax liability, my lords. Subsequently, I participated in the proceedings and an adjudication order came to be passed, against which I filed an appeal, my lords, before the appellate authority. My lords, that appellate authority has dismissed my appeal in limine for non-appearance, my lords. Challenging that order, my lords, I have come before my lords. Reason for non-appearance is that the intimations, my lords, were
Page
uploaded.
number 22, my lord, of the impugned order. Annexure A, my lord.
Opportunities were given, my lords. However, only issue is I did not receive the intimations, my lords. So those were uploaded in the addition.
Understood, my lord, we have sent through portal also updated, email also sent.
Email, my lords,
I
have
leave
not
it to your
received.
lordship on the exemplary cost, my lord. Maybe remanded back.
Yes. The HCGP was saying that apparently you say You pass any order, we'll go there.
That's not the case, but this is a genuine case.
Lighter venance. Many of the lawyers, trial court judges say that they say, you pass any order, we'll go and get. Petitioner.
Exemplary cost must be, my lord, because
Petitioner
everything
has
reasonable
challenged.
means total reasonable agi opportunity kottagide.
Petitioner challenged the order dated 27/5/25 at annexure A.
And date of hearing must be fixed by this honorable court. If he fails to appear, then that order may be restored, my lord.
Whereby in proceedings under 107 clause 11 of KGST Act and CGST Act 2017, the appeal came to be dismissed due to non-appearance of the petitioner. It is a perusal of the order would indicate that the petitioner not having appeared before the appellate authority, proceedings and hearing remained inconclusive. It is further observed that despite all opportunities granted, petitioner has failed to make good his appearance and avail of such opportunity. And in light of non-appearance, the appeal came to be dismissed while observing that it is only in the presence of the appellant that it is practicable for the authority to appreciate the case of the appellant. Counsel to the petitioner submits that the lapse on the part of the petitioner was due to bona fide reasons, and court may pass appropriate orders putting the petitioner on terms. Taking note that the rights of the petitioner would be prejudiced if there is no adjudication on merits. Despite lapse of the petitioner, it will be appropriate to afford one more opportunity by remanding the matter for fresh consideration before the respondent number one. However, in light of the closure of proceedings due to lapse on part of the petitioner to pay costs of rupees 15,000 to the High
My lord,
Court
maybe
Legal
at least maybe 50,000, my lord. They have to understand the consequences of first appellate authority, my lord. How many times we should issue the notice? How many times we should request them for pleading their case?
Let's, if I may submit.
At least 50,000.
I'm ready to deposit additional 10% towards the deposit, my lords. Instead of the cost, my lords may consider that will be around 1.1 lakh rupees. I'll deposit additional 10% towards deposit as pre-deposit. That I'll
15,000 cost plus an additional 10% of the tax.
Instead of the cost, my lords.
No, my lord. It will go to legal service authority,
Malats,
not to us.
15,000.
Malats, otherwise, Malats, I'll only pay 15,000. Malats. Only issue is that Malats.
Much obliged, my lord. Date of appearance, my lord.
The petitioner to appear without further notice before the first respondent on
25th of February.
25th of February.
Obliged.
Fine, Mahesh,
Yavattu.
25th of February.
Could it be on 26th, my lords? 26th.
Serial numbers 5, 6 and 8, my lords, we may have to amend the petitions because during the pendency of these writ petitions, my lords, there's been a subsequent development. So I think some time may be required for us. We'll have to bring that order on record because right now what was challenged was a notice. I'm told, my lords, while this writ petition was pending, orders have now been passed. So we'll have to bring that on.
On behalf of the petitioners, that there are certain subsequent events that requires to be brought on record by way of amendment. Relist the matter.
I'm sorry, what?
When do you want it?
Tuesday, my lords?
Yeah,
I mean,
Tuesday.
I'm there for that, Tuesday. 5, 6 and 8, my lords.
Yes.
Only in 6 and 8, my lords, could your lordships consider the office objections, because there are some invoices, my lords, which were produced, which have been scanned and placed in the notice. We won't be relying upon them.
Only 6.
In fact, we sought for dispensation also.
But the office objection is something different.
But then we'll look into it. Then I'll look into it. I'm sorry, I was told.
It says quashing annexure. All parties not arrayed, just have a look at it.
I'll have a look at it.
Office objections.
I think that has been complied with. Anyway, we'll make an office.
Office objections to be complied with in the interregnum.
Yes.
List the matter in the same stage. Number 8. 8 only copies to be served. You have served.
That
In serial number 8, office objection is complied with. As it is submitted that the copies have been served.
Great.
You serve advance copy on whoever.
No,
you
in
take
fact,
it.
we'll serve it on my learned friend. In fact, 2 of those matters, in fact, 6 and 8, my lords, the coordinate bench just before vacations had passed a detailed order. There are some technicalities on which where once these goods vehicles are directed to be stopped at a particular place, the department has taken the view that it is already a detention. But the detention order has to formally follow subsequently. And there are strict timelines. So based on that, and there's a Gujarat High Court judgment division bench, we placed it before the coordinate bench. There was a direction to release the vehicles, of course, subject to various conditions. So I think 6 and 8, if my learned friend could get instructions whether it can be released on the same terms. But anyway, but we'll serve copies.
Next week, when
Yes,
my,
Tuesday.
my friend M. Kumar will appear.
Correct. Here also appeared.
Yes. 7, Sinapake. Serial number 7. Petitioner in this one.
Writ of mandamus, my lords. Lords, petitioner's father and brother have jointly acquired land to an extent of 5 acre 37 guntas, which was subject matter of acquisition, my lords. Insofar as the
Any case is pending.
no cases is pending, my lords. The parents have died. Now what
Civil-
hap-
Parents have.
Parents have died. Now what they do is kindly perused by annexure L models, page number 105. Insofar as what was released in favor of the brother of the petitioner, he has taken award in the form of sites, which are produced at annexure G. There is a recital, page number 101. There is a recital that there is a release deed, and accordingly, the said equivalent ratio of sites have been released in his favor. I have no dispute with regard to that. The remaining extent, my lords, but page number 105, the authority considers that he is the equivalent owner. They partition this. ಅವ್ರ ಹೆಸರಲ್ಲಿ ಖಾತೆ ಇದೆ ಅಂತಾರೆ. ನಾನು ಖಾತೆನೂ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ 105, 104 ಜಂಟಿ ಆಗಿದೆ, ಮೇಲಿನ ಜಂಟಿ ಅಂತ ಇದೆ ತಂದೆ ತಾಯಿ ಹೆಸರು ಜೊತೆ. ಪೇಜ್ 105, 105 ಜಸ್ಟ್ 104, 105 ಜಂಟಿ ಅಂತ ಇದೆ. ಅವ್ರ ಹೆಸರಲ್ಲಿ ಏಕೈಕವಾಗಿ ಖಾತೆ ಇಲ್ಲ.
Narasamma and
ಚಂದ್ರಶೇಖರಯ್ಯ, ರಂಗಶಾಮಯ್ಯ, Narasamma parents, they are deceased. They have died. They died in the month of June, July 2025.
106.
Yes, my lord. 106, they proceed to.
No. Survey number 106.
Yes, my lord. Both survey number 106. Survey, there are 2 survey numbers involved, my lords. There are 3 properties totally involved, which are made at schedule of my petition, my lords. I have mentioned the survey numbers.
What do they say at annexure L?
Annexure L, they say, Sadri 3 acre 15, second para, my lords. Sadri 3 acre 15 ಗುಂಟೆ ಜಮೀನ ಪೈಕಿ ಚಂದ್ರಶೇಖರ ಚಂದ್ರಶೇಖರ ಬಿನ್ ರಂಗಶಾಮಯ್ಯ ಅವರು RTC ಅಂತ 1 ಎಕರೆ 12 ಗುಂಟೆ ಜಮೀನಿಗೆ ಖಾತೆದಾರರಾಗಿದ್ದು ಐ ತೀರ್ಪು ಆದೇಶದಂತೆ 1 ಎಕರೆ 12 ಗುಂಟೆ ಜಮೀನಿಗೆ ಹಕ್ಕು ಸಾಬೀತುಪಡಿಸುವ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸಿರುತ್ತಾರೆ. 1 ಎಕರೆ 12 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣ ಐ ತೀರ್ಪು 40-60 ಅನುಪಾತದಲ್ಲಿ 12.00 ಚದರಡಿ ನಿವೇಶನಗಳನ್ನು ಮಾಡಲಾಗಿರುತ್ತದೆ. How can they, my lords? Yeah, I don't have any rights. There is a document released by the parents in favor of him insofar as 2 acres and annexure page number 101.
In light of the contention that the petitioner and
His family, brother and parents.
Petitioner and the brother are joint khatedars.
Yes.
With respect to survey number 106, which is stated to have been acquired. It is submitted that offering of developed land only to respondent number.
He is not made as a respondent. I'm seeking a writ of mandamus, asking the BDA to consider my claim as well. I have made a representation. The said recipient is not a respondent. My grievance is the BDA is acting as a civil court.
Correct. Why don't you make him respondent there instantly? Okay, let us see. Then you just take out notice.
Till then, BDA may not proceed with disbursement.
That's why you make him a party. I'll give you permission now.
I'll make.
Respondent newly added in particular.
T.R. Chandrasekhar.
The newly added private respondent would be contrary to the joint interest, including that of the petitioner in the said land. Accordingly, subject to further consideration, respondent number, the respondent BDA not to disperse compensation to any of the parties till the next date.
Much of.
Till the next date. BDA.
Lakshmi
Shah was directed to accept notice for BDA. Petitioners permitted to amend the cause title to include his brother as an additional respondent. Necessary amendment to be carried out. Notice to newly added respondent.
Much of.
8 urgent, serial number 9. Virupaksha PH.
For the petitioner. Petitioner is challenging the general award minutes passed by the third respondent authority at page 21 in respect of the land owned by the petitioner in survey number 139 measuring to an extent of 2 acres 1 gunta.
General award. You're seeking any land or only
consent? Consent only consent award.
Already one dispute is pending before the civil court. He is saying that dispute is already settled.
The parties have settled before the civil court.
But subject to lordship, if the dispute will arise, the general award will be reviewed.
What do you say regarding the dispute?
Dispute is settled between the parties before the civil court.
And counsel, she so and so accepts notice.
2 and 3 Melon.
2 and 3 AGF accepts notice for the first respondent. Repeat all paras. One paragraph admitted. Petitioner para 6. One paragraph admitted. Petitioner submits that though there is a dispute, said dispute has been settled, and accordingly there is no impediment for the respondent authorities in passing a consent award. Third counsel for the third respondent submits that they would verify the said submission and proceed further in accordance with law. Petition disposed.
10. Sanmati.
Your Lordship, petitioner is involved in the business of lubricants, my lord, and grease. The petitioner is challenging the order passed under section 73. Your Lordship, GST DRC 1A notice has been issued to the petitioner on 25/9/2025. Your Lordship, only a day's time was granted to file reply within 26/9/2025. Only a day's time was granted. I filed a letter, gave some details and also sought some further time to produce the documents, but same was rejected, and immediately next is GST DRC 1 notice was issued on 29/9/2025. I filed the reply for that one along with certain documents. Your Lordship, the same has been rejected and impugned order has been passed. Impugned order has been passed on the ground that have not produced, Your Lordship, page number 18, my lord, tabular column. This is the reasoning.
Fresh matter.
Fresh matter, my lord.
Maybe remanded back, but time is given, sufficient time is given. They have filed a reply also. Kindly be seen, my lord, page number 13, last line, my lord. In response to it, you have filed reply in GST DRC 01A Part B on 26/9/2025, which is reproduced as under. After considering their reply, we have passed an order. He wants further time, my lord.
Your Lordship, my
He
respect
can
is,
go first appellate authority, then he can take all his contention. Alternative remedy is available. If your lordship wants to remand back at all, means subject to cost, my lord.
Your Lordship, GST DRC 1A is given to the dealers not to enable.
Same contention, they can have a
I will,
appeal remedy, my lord.
I am making legal submissions, my lord. Your Lordship, GST DRC 1A is given. Your Lordship, 1 day time is granted. Your Lordship may kindly see when an opportunity is really given to the dealer, it should be a practical one. It should not be that for formality purpose, they give 1 day time.
Annexure C.
Your Lordship, Annexure C, my lord. Your Lordship may kindly see GST DRC 1A, my lord, Annexure C. Your Lordship, it is dated 25/9/2025. Calling me to give, Your Lordship may kindly see the notice itself runs to 2.5 page. And I have been given a day's time, 26/9/2005, I have to give reply.
Where is that?
Your Lordship, page number 26. In case you wish to file any submissions against the above ascertainment, the same may be furnished by 26/9/2025. Your Lordship, for this one, I filed a reply stating that I need certain time. Your Lordship, that is at page number 14, my lord. Your Lordship, page number 14, in part B, it has been extracted. In part B, Your Lordship may kindly see page number 15, the extraction is there from 8 to 3. I have also made legal submissions, whether trade discount GST is applicable or not. I have raised a legal dispute, and we are enclosing copy of the GSTR 9 and 9C for your reference. We are request you to cancel this good self to kindly provide 1 month time. Your Lordship, why I am asking for 1 month time, Lord? Just as section 73(8), Lord, provides 30 days time for me to either to admit or to file reply to the notice. Your Lordship, a reasonable time, even if it is not for 30 days, they should have granted reasonable time. I am a registered dealer, Lord. My supplier is
Correct. So now it will go back to which stage?
to reply to GST
Purpose
DRC
noted.
1A.
No, my lord, actually alternative remedy is there, my lord. If at all, we, page number 13, my lord, we have considered their reply. They have given a reply, we have considered and passed an order. If at all your lordship wants to remand back, means subject to cost, remand back before the adjudication
Your Lordship,
authority at the stage of show cause notice.
Your Lordship, reply to GST DRC 1A, because if if I able to satisfy the officer,
With the stage of reply to communication under 142(2)A.
yes, 142 2A, my lord, dated 26/9/25.
The petitioner has called in question.
My lord, it is an intimation, my lord.
No, he has made out a request at page 15 for
Yes,
further 1 month time. So we'll send it to that stage. The petitioner has called in question correctness of the order under 73(9), which is an order under section 73(9) dated 6/12/2025. Which is the case of the petitioner that an intimation and inform GST DRC 01A dated 25/9/2025 was issued, which was a detailed intimation
Allah.
with several grounds.
Pardon, my lord.
With several grounds.
Annexure C,
The subsequent reply.
Advising the petitioner to pay the amount as ascertained. Further opportunity was granted to file any submissions against the ascertainment by 26/9/2025, that is within 1 day. Petitioner submits that he sought for further time.
Yes, ma'am.
Further time of 1 month
Yes,
after making out a reply. And reason for such time was that he had to gather details and information. It is admitted that despite such request, the authority has proceeded to adjudicate
And issue show cause notice.
and issue show cause notice.
In GST DRC 1.
In GST DRC 01.
And for that one also I filed reply.
Petitioner submits that he may be afforded further opportunity to put forth his reply as requested and opportunity and time be granted. AGA submits that the reply of the petitioner has been considered and orders passed. And if the order was passed without any reply, the court may have reopened the proceedings. It's heard both sides. Notice that the intimation in form GST DRC 01A of 25/9/25 had granted 1 day's time. That is, submissions to be filed by 26/9/25. Petitioner, after making out preliminary submissions, had requested for a month's time, and such fact is borne out in the order. The adherence to principles of natural justice would require another opportunity to be granted to the petitioner. Accordingly, it would be appropriate to set aside
Your annexure A and B, my lord.
annexure A and B while remitting the matter to the stage of reply to DRC 01A.
No, my lord.
01A, my lord.
Show cause notice, my lord. After considering reply of the DRC 01A, show cause notice is issued, my lord.
Your lordship, show cause notice is issued DRC 1.
In show cause notice, detailed hearing will be conducted, my lord. Opportunity will be given. Then only appropriate order will be passed.
Where is that show cause?
DRC 01A is the intimation, my
So
lord.
correct. So we send it to
Show cause notice annexure C1, my lord, page number 28, my lord.
One submission, my lord. Your lordship, GST DRC 1A, if I am able to give reply and satisfy the officer, then my lord, if he is not satisfied, he will proceed to 1. Your lordship, 1A will lead to penalty also. Your lordship, I will be more burdened if I am not been granted sufficient opportunity to give reply to 1A.
My lord, maybe, my lord, but we have considered his reply.
Your lordship, section
He
itself
has
clearly
given a
says.
reply.
Just one, correct. But you just go to the order at page 15.
Yes, ma'am.
My lord, bottom, my lord, the reply filed by the taxpayer as above is verified
So correct. The box.
and could not be considered as no relevant documentary evidence
just
as
one.
prescribed.
No, correct. That box just above that.
My lord, it is entire his submission is extracted, my lord.
No, that box is there. We are enclosing.
We are enclosing copy of GSTR 9 and GSTR
he's-
9C for your reference. We are request your good self to kindly provide 1 month time to give more clarification. My lord,
So here.
my
no doubt
lord,
You have
to
rejected his
what happened, my lord? There is a limitation for us. Limitation is prescribed, my lord. What they will do, they will drag the matter. Just keep on dragging the matter. That is the tactics. To avoid, we requested, if it is GSTR 9 and 9C, they have to give then and there if they are updated. Why 1 month is required? Reasonable time is given, my lord. At least for the sake of argument, leave it, my lord. We have issued show cause notice. There sufficient opportunity will be given by this honorable court. We will consider their submission will drop the proceedings only. If they have a documents.
That is at annexure.
Annexure C1, my lord. Page number 29/9/2025.
So we'll set aside this order at annexure A.
A, B.
And
Yeah, my lord.
Yeah,
It will vitiates entire proceedings. Then let him.
Just 1 minute.
Yes, ma'am.
So now, if we are to remit it back to show reply to C1.
C1, my lord. That's all, my lord. I request that's all, my lord.
So we don't have to set aside anything.
Yes, my lord. A is set aside, A and B, my lord, demand and order.
Order it.
Your Lordship, for a moment, my lord, may I read section 73(8), my lord. It clearly says, my lord, 30 days time has to be granted, my lord, even to pay the tax.
Lord,
Your
if
Lordship
my
may-
learned friends wants to argue, my lord, I will file a detailed statement of objection. I will oppose for remanding back. They have to avail the alternative remedy. If it is going before the, at the stage of show cause notice, I will not object, my lord,
You just see.
because they will get the justice.
Your
I'm
Lord-
sure this system is for to get the justice only.
Yes, Sanmati.
Your Lordship, one day, my lord,
Take a
whether it can be said as a reasonable time, my lord.
That we'll see, but they are saying they'll file their objection. You either take it or we'll consider something, let them take the stand, we'll see later.
Your Lordship can send it back to the what the learned council is
Section
considers,
A
my lord.
and B set aside, matter remitted to the stage of reply to show cause notice under section 73(1) at annexure C1. All contentions are kept open.
But your Lordship, in any one of the case, your Lordship has to lay down the law, my lord. When GST DRC 1A is issued, my lord, all officers are giving only a day's time, my lord. At least 30 days, my lord, or 15 days, whatever, the reasonable time has to be defined, my lord.
Let us see. Yes.
Much obliged, my lord.
11, Mahesh Vagan.
11 and 13 also, Manoj. The only difference being that there's no subsequent development here. This also could be taken up on Tuesday.
11 and 13.
Yes.
Relist on Tuesday at request in the same stage. You serve copies.
We'll serve copies. We'll do that.
Yes.
Serial number 12,
Copies already served, Manoj, but we'll do it in case it's not done.
Yes.
12, Ganapati Bhatt. Serial number 12, Murugeshwari.
In this case, my lord, this is my lord site which we have.
Directed me to identify as to what has happened to this writ petition, which not in the.
Insofar as layout plan is concerned, my lord, that your lordship directed. Before that, my lord, I'll draw your lordship's attention
1994 writ petition.
about
Which was mentioned, but I tried to secure through internet, I have asked the PDA to search for that file and give it to me.
I have applied for.
On Monday, by then, I will be able to secure 1994 order in respect of the very same petition schedule problem.
Lord, my lord,
So let us see. I just want to have a look at that order and we'll.
my respectful submission is this, brother. There are two options, my lord, for me. Insofar as, my lord, their own statement says that there are 52,000.
Correct. Let's have a look.
And one second, my lord, with great respect to your
No,
lordship.
without that.
Alla,
order,
one ನಿಮಿಷ ನಾನು, because my lord, position which from 1965, I'm there in position. Supreme Court, under these circumstances, if they have not, I am continued prima facie established that, my lord, that I am in possession of the property. This court entertained under 226, 227 of Constitution of India. And my lord, we are entitled for getting justice. That is Supreme Court. Insofar as 38C may kindly be seen for a moment.
that I'll see it.
ಅಲ್ಲ ಅದರಲ್ಲಿ ನನಗೆ ಎರಡು ಆಪ್ಷನ್ ಇದೆ ಸರ್. ನಾನು ಒಂದು ಸಬ್ಮಿಷನ್ ಮಾಡಿ. ಒಂದು, I have to, if at all, my lord, your lordship, my lord, permit me to go to civil court till then auction to be stalled. I'll go for civil court. Otherwise 38C ನಲ್ಲೂ ಕೂಡ ಹೋಗ್ಲಿಕ್ಕೆ ಅವಕಾಶ ಇದೆ ನನಗೆ. BDO amended act ಅಲ್ಲಿ. If at all, my lord, I am able to establish 38C.
38C2 is not in existence at all, did not come into picture at all. But there is that it ought to have come into existence by virtue of a notification. That notification was never published. This court had an occasion to look into it. That this court.
That you just give that copy.
Yes.
In many petitions, they're saying same, covered by, we are also.
38D, 38D is a new enactment in 2020. For that, there should be an existence of a residential house prior to 12 years prior to 2020. That the cutoff date will come to 2008. From 2008, if it is in existence, even though unauthorized also, but if it should be a Pakka residential house, then they will have an provided lot. I should not be in a position to develop the property. If I can develop and if I
We'll have it on Monday.
My lord, one submission. Since, my lord, if they are confirming portion of the site, Let them, my lord, I'll deposit, my lord, in case, my lord, that amount, if at all, my lord, I'm not able to get the sites allotted, because, my lord, if they have auction portion of the site, my lord, then, my lord, I will have to face two front, my lord, one BDA and purchasers. Therefore, my respectful submission before this court,
The auction already over.
auction is not over,
Auction is not over.
not over. Therefore,
That what happens. Moment it's admittedly no structure in their sale deed. Not a person sleeps over anything, if anything could have been done. This 38C.
We'll have it on Monday.
Please.
Released in the same stage on Monday.
because if at all, my lord, I am able to file even declaration suit, if at all, my lord, for possession, I can avail the benefit from BDA. Under those circumstances, let them take, my lord. I will not say, if at all your lordship puts condition to deposit certain amount before this court, I'll deposit. Provided, my lord, that I am failed to succeed, my lord.
Let us have a look at what that order says.
ಅದು ಆಕ್ಷನ್ ಕನ್ಫರ್ಮೇಶನ್ ಆಗೋದ್ರೆ
Let us
ನನ್ಗೆ
see.
ಏನು ಉಳಿಯಲ್ಲ ಅಂತ ಅಷ್ಟಕ್ಕೆ.
Monday will see. Please. Yes.
13 and 14, 2-3 over there, 14.
For petitioner. The land bearing survey number 101, measuring 28 guntas, belongs to respondents number 3 and 6, your lordship. This said land was notified by the annexure A in the preliminary notification dated 29/3/2000.
You are now calling in question order of the.
Order of the Assistant Commissioner by the annexure H. Mine's one page 92, your lordship. Here, what has happened was, your lordships, award came to be passed. Being aggrieved by that award, the respondents number 3 to 6 herein have preferred section 18 reference. Section 18 reference or reference court has also passed an award. Against, after passing of the award by the reference court, the respondents number 3 to 6 herein have filed an application under section 28A. My respectful submission to your lordships is that when they have approached the reference court and an award is passed by the reference court, so application under section 28A is not maintainable.
You are challenging the 28A.
28A application.
There's
Now
no-
against,
There's no other statutory remedy.
there is no, because after passing of the award by the reference court.
See, 28A.
No. Appeal is.
So once they have gone in reference proceedings, they can't go to 28A.
28A. The lordship kindly turn to section 28A.
Put it-
And
old-
also.
Old land acquisition, I put it. Old land acquisition.
Or may
28A
pass
come-
28 capital A of Old Act. This is the judgment wherein Pradeep Kumari case, the Honorable Apex Court has held that under what circumstances 28A application can be filed. Page 740,
Not have gone.
page 743, your lordships. Page 743. From the bottom, your lordships would get the object underlying, your lordships got it. The object underlying section 28A would be better achieved by giving the expression and award in section 28A its natural meaning as meaning the award that is made by the court in part 3 of the act after coming into force of section 28A. If the said expression in section 28A is thus constitute, a person would be able to seek redetermination of the amount of compensation payable to him, provided the following conditions are satisfied.
Clause 4.
Clause 4.
Huh?
Clause 4.
Now their reference here,
Their reference is, your lordships, page annexure D, page 33. Page 33. The lordships will get a cost title. The respondents number 3 to 6 herein are LRs of Malli Desamma. And your lordships will get the name of Malli Desamma in preliminary notification at serial number 16, page 17.
the petitioner has called in question validity of the order at annexure H, whereby benefit under 28A has been afforded to the private respondents herein.
Application is at annexure G, page 88, Your Lordship. Where fraud is played, I have taken that contention.
It is a contention of the, further contention of the petitioner that once the private respondents had approached the reference court and have obtained an order and order passed as evidenced at annexure D, question of resort to 28 capital A of the Land Acquisition Act does not arise. Reliance is placed on the judgment of Union of India and others versus Pradeep Kumari and others, 1995 to SCC 736. In light of the contention urged, there would be stay of the order at annexure H. AGA accepts notice for respondent 1 and 2, emergent notice to respondents 3 to 6. Petitioner, you want to take out any other mode of service?
I can serve them hand summons also, Your Lordship, because they have again filed.
Is by way of hand summons as well.
15.
In this matter, Your Lordships, there is
28A. Yes.
Here in this matter, so serial number 15, there is violation of condition number 3, which states that Your Lordships in that judgment.
Judgment.
Condition number 3. The person moving the application under section 28A is interested in other land covered by the same notification under section 4(1) to which the said award relates. Now, Your Lordships, here, the land of the respondent, private respondent was notified in the year 1984.
Different notification.
Now they are claiming they have filed application under section 28A in respect of some Dasharath, whose land was acquired in the year 2009.
Now his land is in which year, which notification?
5/9/1984, annexure A.
5/9/1984,
annexure A.
(5/9/84).
84, annexure A.
Now
now they are claiming, relying upon the notification dated annexure D, page 48, 29/3/2009.
40.
Page 48, print money notification dated 29/3/2009.
Petitioner, you must stitch the pages properly. Prithvi, you must stitch the pages properly.
I'm sorry.
Now we have become a little lenient in the office objections. The petitioner submits that the now order is passed, is it?
Now order is passed. Now he has preferred execution petition and execution petition is pending. Execution.
Where is that order in 28A?
28A order is annexure J, page 99. Application is at annexure H, page 95. Order is at annexure J, page 99.
Petitioner is called into question validity of order under 28A at annexure J. It is a case of the petitioner that the land loser, if is to seek benefit of extension of higher compensation under 28A, necessarily the land of the land loser must be relating to a notification and the award passed of higher compensation must also relate to the same 4-1 notification. It is submitted that the order passed under 28A is by taking note of higher compensation with respect to a different notification and not the notification under which petitioner's land has been acquired. In light of the said contention, there would be stay of the award
Order Annexure J.
at Annexure J and execution proceedings
12 of 2021.
12 of
2021.
12,
Annexure K.
12 of 2021 at Annexure
K, Your Lordship, page 114.
at Annexure K. But you have come late, you could have come
But
earlier.
here in this case, there was a discrepancy in the survey number. In the year 2024, he files an application seeking for rectification under Order 6, Rule 17. Now, Tiddupadi Adesha was passed in the year 2000, Annexure L, 14/10/2024.
AG accepts notice for respondents 1 and 2. Emergent notice to third respondent. Petitioner is liberty to take out notice by way of hand summons to third respondent. Yes.
16.
Macho.
Rakshita TJ.
Oh, yes.
For the petitioner in this matter, yesterday's matter, your lordship had directed me to serve a copy and learned counsel for BDA, my lord. Lord, the petitioner is the owner of land bearing survey number 71/7B.
Before commencing, so far as first prayer is concerned, in view of the division bench judgment, I have no objection to dispose it of. And remaining two prayers, my lord, is concerned, I'll file. They are pressing the remaining two prayers, my lord. I'll file my objections and I'll take instructions, further instruction and file objections. The validity and accusation was upheld by the division bench and seeking two more prayers. And if he is considering the representation as per prayer 1 is concerned, I have no objection if it is disposing of in view of the prayer number 1.
Now this validity was upheld.
Yes, but
The acquisition, my lord, if your lordship recollects a series of matter Nada Prabhu Kempegowda.
So correct. Now he is saying prayer 1 he is ready to consider.
Please, my lord, but what happens even the division bench, if I'll take my lords to the order, page 69, my lord, it starts at annexure K. Page 72, my lord, would be relevant. Page 71 at the last A, my lord, where it's mentioned with regard to the landowners. If your lordship sees at page 71. Last, my lord, with regard to landowners as in case of present petitioners. All the landowners, writ petitioners who are seeking for dropping of their lands from acquisition on the ground that their lands are nursery lands situated within green belt, totally built up, buildings are constructed by religious, charitable, educational institutions. Similar adjoining lands have been either left out from acquisition or denotified, are permitted to make an application to the BDA seeking for dropping of their lands from acquisition by producing all such materials that they deem fit necessary in support of their application within 3 months from today. Further, my lord, the BDA shall consider each of the said applications keeping in mind the status of the land as on date of preliminary notification and without taking into consideration any development, improvement, construction made subsequent to preliminary notification. Thereafter, my lord, page 75. What the division bench did was, my lord, it classified with regard to landowners and site owners. Petitioner is a case of landowner. Page 75, my lord, clause 4. Till the aforesaid exercise directed to be undertaken by the BDA and the applications filed by the writ petitioner either for allotment of sites or for dropping of the lands from acquisition are concerned, their possession shall not be disturbed and the existing construction shall not be demolished. So even the division bench, my lord, has clearly provided a rider as to the BDA cannot. Now, my lord, in terms of the direction issued, page 77, my lord, annexure L. I have preferred a representation enclosing all the details. My land consists of built-up structure. And my lord, if your lordship sees the Mahazar,
That they consider this.
We'll consider it and till then dispose, will not take any.
they are not doing that, my lord. It's
No, he
been
said-
1 year.
The time limit may be fixed, my lordship can fix the time.
It's been 1 year. That is why, my lord.
No, I don't know how they can backdate to see what was the property as on the date of.
Like, that is because we have produced the Mahazar itself as on date of
Let us see, they'll examine it.
Yes.
The petition.
page. Not similar orders wherein final orders are passed. Even in this case, my lord, on the same lines as per the directions issued, page 8, your lordship will find.
So para 10.
Para 10 is the entire
Hmm.
division bench order is extracted, my lord, and further, till such exercise is done,
That will
the BDA cannot take any precipitative steps.
the petitioner have sought for issuance of a writ of mandamus to direct the respondent to consider representation dated 21/5/2024 at annexure L and objections at annexure N1 in terms of the order passed by the division bench in WA 1783 of 2014 and connected matters disposed of as per order dated 22/2/2024. Though certain other prayers are sought for, counsel for the respondent BDA submits that if the petitioner were to limit prayer to prayer number 1,
please,
in light of the orders passed in WA 1783 of 2014 and connected matters, they would consider the same as per law. Full stop. Accordingly, taking note of the stand of counsel for the respondent BDA, the present petition is now disposed of only insofar as prayer number 1 is concerned. Full stop. It is the petitioners claim to be landowners whose land came to be acquired for the Nada Prabhu Kempegowda layout. Full stop. The petitioners claim that their land be left out of the acquisition process. Reliance is placed on the order of the division bench. Full stop. The relevant observations of the division bench in writ appeal
Annexure K, my lord. 69 page number.
WA 1783 is it?
Please.
1783 and connected matters.
In WA 1783 of 2014 and connected matters would be of relevance, and the operative portion of the order is extracted as below. Full stop. It is noticed that the direction insofar as the landowners is found at para A,
A 1, 2 and
A, Roman 1 to
till 5, my lord.
1 to 5.
B is for site owner.
Yes, next. In light of full stop. Next, taking note that coordinate bench in WP 29798 of 2025 has also passed similar orders on parity. Petition could be disposed of. Taking note of the same. Observations of the coordinate bench in WP 29798 of 2025, para 9 to 11 reads as follows. Next, accordingly, in the present matter also, taking note of the stand of the respondent BD is directed to consider representation of the petitioner at annexure
At
L.
annexure L and
L.
L1
annexure L. In
and
terms-
N1.
L and
N1 also.
N1.
N1.
L1.
N1.
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 L and N1. And dispose of the same, keeping in mind the directions of the division bench in WA number 1783 of 2014. Next, needless to state, respondent BDA shall not take any precipitative steps above. Accordingly, petition is disposed. Great.
But if your lordship permits me, the schedule, my lord, instead of Yeshwantpura Hobli, it's wrongly mentioned as Kengeri Hobli. If I may correct it.
Petitioner is permitted to amend the schedule. Yes.
Grateful, my lord.
17, Uday Shankar M.
That's for the petitioner, my lords.
Please to
Lords, this is a GST writ petition challenging the ex parte orders passed by the respondent, my lords. My lords have already passed an order. I'm just placing it on record, my lords, where I'm seeking a remand of the matter. My lords. Challenge the notification number 9 and 56, which is pending before the Supreme Court, my lords. Notification number 9 and 56, which extended the limitation period. I have challenged that, my lords.
My lord, that cannot be taken into consideration. Let them go back and on merit, all contention kept open. Let them take the contention before the respective authorities.
My lords may pass an order which notes that the limitation period has also to be examined, my lords. In a similar matter, my lord, it's remanded back. Same contentions was taken in that case also, my lords. That is not mentioned, my lords, but I argue that matter, my lords. It was sent back. All contentions kept open is what my lords had directed.
But it is 33, 2023 order, my lord.
My lords, what usually the coordinate
The
bench used
almost
to.
2.5, 3 years old, my
That's
lord.
1.5 year delay, my lords. I was not effectively served.
They will tell, my lord. Portal
My
alli
lords,
serve ಮಾಡಿರ್ತೀವಿ,
what I
ಎಲ್ಲ
wanted to bring to
ಹಾಕಿರ್ತೀವಿ.
my lords notice is with respect to the order in 4, my lords. What the coordinate bench used to do is it used to remand back, but the period is to be excluded. This was the direction given, my lords.
That need not necessary to follow, my lord. Matter
Was
may be
the coordinate
remanded
bench
back
what it was
to
doing?
Cost, my lord, before the legal services authority, and all contention, whatever they want on merit, let them take before
Let
the
them also
respective
examine
authority, my
this aspect, my lords. That's all. My humble prayer. And my lords, my name has to be brought on record, my lords.
Office to show name of learned
It's filed
counsel.
in my name, but
Counsel for the petitioner as
Pranay Sharma, my lords. It's in the presentation.
yes. Petitioner is sought for setting aside of an order passed under 73(9), which is an order of adjudication for the financial year
2018-19 and 19-20, my lords.
2018-19.
Two order, my lord, two assessment.
Two assessment years, my
adjudication
lords.
order.
At annexure A1, and petitioner is also challenged the order of adjudication under 73(9) for the financial period. For the tax
2018.
period.
Annexure A1 is
A1 is
2018-19, my lord.
18-19, my lords.
B1 is 19-20, my
2020
lord.
At annexure B1.
B1 page number 68, my lord.
Consequential, orders and proceedings have also been challenged. It is the case of the petitioner that the order at annexure A1 as well as B1 were ex parte orders, and petitioner could not participate in the proceedings nor make out reply to the show cause notice.
I was not effectively served because it went and sat in the view additional notice column, my lords, not in the general notice column.
All notice will be served in additional notices only, my
My lords,
lord.
there are
Alert
contrary
system is
decisions,
there,
my lords,
email
which
is
says
there,
that it has
their
to be served
mobile,
on the view
their
notice.
mobile number is there.
He submitted that the petitioner was not aware of such proceedings, and petitioner subsequently came to know of the proceedings.
When I received a telephonic call from the department, my lords, in the year 25.
A telephone call from the department. HCGP would submit that notice has been served as per procedure and there is no lapse. And lapse, if any, is solely attributable to the petition. Next. Taking note that order of adjudication is admittedly passed without reference to any reply of the petitioner.
Yes, my lords. I have not filed because.
My lord, my submission may be recorded, my lord.
I've taken.
Yes, my lord. Contrary to the their contention.
I've taken.
Yes.
Appropriate to set aside the order of adjudication at annexure A1 and B1 and remit the matter back to the stage of reply to
Show cause notice. At annexure A3, my lords.
Show cause notice at annexure
A3.
for both.
For both A3 and B3, my lords. For 2 different years. So.
Accordingly, the orders at annexure A1 and B1 are set aside. Petitioner to make out the reply to the show cause notice at annexure A3 and B3.
B3, my lords.
For the respective tax
Financial
period.
period.
All contentions on merits are kept open. Consequential proceedings at annexure.
No consequential, my lords.
That's all.
A2 has to also to be quashed, my lord. But that is a summary of the order in original. A2 and B2.
Consequential summary of the order at annexure A2 and B2 are set aside.
Yes, my lord.
Petitioner to appear before.
Respondent number 1, my lords.
Respondent number 1 without further notice. On.
My lords, the following week or first week of March, my lords, because I'll produce every document at
Date
once.
may be fixed, my lord.
4th
of March.
Needless to state, if the petitioner does
My
not
lord,
avail of
cost
such
two assessment order, my lord.
would be disentitled of the indulgence granted by the court. Petitioner to pay cost of rupees
10,000, my lords, if I may request.
10,000 to the High Court Legal Services Committee.
Deeply obliged, my lords. Grateful.
Yes.
18.
Obliged, my lords.
Yes.
It is a ex parte assessment order, managed. Two assessment years. Assessment year 18-19, assessment year 19-20. All the notices, everything have been sent to an email ID which is registered to an employee who has left my employment. Therefore, I was prevented from sufficient cost to replying all the notices. I seek for a remand back to the stage of 148 AB notice.
Yes.
Sent to the email ID which was given in there.
You're challenging which order now?
The assessment orders and the penalty orders, consequential penalty orders.
Annexure?
For the assessment year 19-20, it's annexure A1, my lords. A1 to A9.
A1
to A9 is for annexure assessment year 19-20. And annexure C1 to C6.
A1 to A9 is for year?
Assessment year 19-20, my lords. The assessment order and the penalty orders. And the 148 notice and 148 AD order for 19-20 is B2 and B3, my lords. And for 18-19, it's annexure C1 to C6. And D2 and D3, my lords. Only B1 and D1 will survive, my lords.
248 notices?
B3 for 19-20 and D3 for 18-19. D3, my lords. D3.
D2 and D3.
D2 and D3. And B2 and B3. B1 and D1 will survive, my lords. 148 AB notices.
The assessment order is at A1 and
C1, my lords.
C1. The petitioner.
The orders are 2023 orders, very old orders. It's an appealable order, my lords.
Best judgment assessment.
Best judgment. My lords, we've sent a communication to their registered email ID. My lords. They have not responded.
Petitioner has called in question the validity of the assessment orders at annexure A1 with respect to the assessment year 1920.
1920 is at A1, my lords.
Assessment year.
Assessment year
1920.
And assessment year
order-
1819 at
And the order at the annexure C1, which relates to the assessment year 1890. Petitioner submits that the said orders are ex parte orders. And petitioner was not in a position to make out reply to the show cause notice. It is submitted that the notices were sent to the email ID of the employee who had since left the services of the company, and accordingly petitioner did not have information regarding the same. Counsel for the respondent revenue submits that email ID to which notices were sent were email IDs furnished by the petitioners, and accordingly it cannot be contended that the orders were one without notice. Further submitted that the relationship between the petitioner and employee cannot be taken note of, as it's an internal matter of the petitioner company. Next. Third, both sides peruse the order at annexure A1 and C1. It is noticed that the orders passed are on the principle of best judgment assessment. There is no reference to any reply to the show cause notice. Full stop. The assertion, full stop. It would, taking note of the consequences that visit the petitioner, it would be appropriate to afford the petitioner to take his stand on merits by making out reply to the show cause notice. Full stop. The lapse of the petitioner could be condoned, taking note of the financial prejudice that may be caused if the orders are allowed to stand by putting the petitioner on terms. Accordingly, the orders at annexure A1 and C1, that is the assessment orders for the respective assessment years of 1920 and 1819 are set aside. Annexures A2 to A9 and C2 to C6.
C1 to C6.
C2 to C6 are set aside. Matter is remitted to the stage of reply to the show cause notices. Show cause notice.
148 AB notice. 148
Not
capital
148 AB notice. Show cause notice to the, in the assessment proceeding.
Well, I have to file my return in response to the 148 notice, my lords.
So correct. Now you go there to this
148
go
AB
to the show
stage.
cause notice. There, if you want, that we'll see.
Well, but I won't be able to file a return in response to the 148 notice, my lords. That itself was not received by email ID. It may be sent to the stage of 148 AB, my lords. I'll file my return and then I'll contest the matter.
Accordingly, no, otherwise let him file his return.
We wish to send us
Go back to the stage of 148 AB. minutes.
Accordingly, matter is remitted to the stage of 148 capital A small b notice at annexures
B1 and D1, my lords.
B1 and D1 for the respective years. All contentions on merits are kept open.
Great.
Petitioner to pay costs of rupees 20,000 to the High Court Legal Services Committee.
19, DP Shivkumar.
My lords, passover may be granted, my lords.
Passover. Yes.
For 20, Prashant?
Yes.
Page, page 43, Your Lordship. These are prayer. To issue a writ in the nature of mandamus declaring that the Constitution does not empower the Union government to promulgate a law to levy health securities, say national security cess, on the presumed deemed manufacturer, and consequently the health security national security cess, health security national security cess rules are unconstitutional. To issue a writ in the nature of mandamus declaring that levying health security cess on the capacity based production is ultra vires Article 14. 3, Your Lordship, C, when the levy is based on assumption of quantity manufactured instead of the actual quantity manufactured. A particular background, Your Lordship, to this controversy. My Lords are aware, after the introduction of GST, Your Lordship, there are practically 3 types of commodities that are there, Your Lordship. One, which are not subjected to GST, like, Your Lordship, petroleum and petroleum products, that they have not yet notified. The other, Your Lordship, is products like tobacco products, which they still retain, Your Lordship, in entry 84, list 1. So on tobacco products, Your Lordship, they levy excise duty, they also levy GST. So that, Your Lordship, is a separate controversy, whether they can still levy excise duty in addition to GST, Your Lordship, that's a separate controversy on tobacco products. The third, Your Lordship, is products like pan masala without tobacco. On pan masala without tobacco, Your Lordship, only GST is leviable. Now, pan masala without tobacco, Your Lordship, was subjected to a GST of 28% with a compensation cess, Your Lordship, of 60%. And this, Your Lordship, was on the actual quantity that was supplied. So if I have 100 packets, Your Lordship, on 100 packets, whatever be the amount I realize, on that, Your Lordship, I am supposed to pay 28% GST and 60% as compensation cess. And this compensation cess, Your Lordship, was based on the 101st Constitutional Amendment, where, Your Lordship, all the states and the center agreed that if there is a loss on account of implementation of GST, then they should be compensated. So there was a separate compensation cess act that was enacted. So in terms of that, Your Lordship, the 60% compensation cess, Your Lordship, was levied. Then in 2023, Your Lordship, the 60% was replaced by 32% of the retail price. So they moved away, Your Lordship, from the transaction value. It was made as 32% of the retail price. So we had, Your Lordship, a GST of 28% and a compensation cess of 32% of the retail price. Now the compensation cess act, Your Lordship, had a life of 5 years in terms of the 101st Constitutional Amendment. Subsequently, Your Lordship, through the Parliament, they extended it by another 2 years. So it has to come to an end in 2024. So the government said we are going to integrate the cess along with the GST. So then now, Your Lordship, from 1st February 2025-26, the rate of GST has been increased to 40%. Instead of 28%, Your Lordship, has been made 40%. And 40%, Your Lordship, is on the retail price. Whatever be the maximum retail price, on that minus the deductions, this 40% tax is being levied. So today, Your Lordship, all the pan masala manufacturers will be paying 40% GST, the enhanced rate, on the maximum retail price. Now this compensation cess having gone, they now enact an enactment saying that we will now levy cess based on the machines which you install in your factory. That is why, Your Lordship, this page 47, if my Lords could see, this is the act we have challenged. There are 3-4 grounds we will take, Your Lordship. I'll just point out what this, Your Lordship, is the health security national security cess. May Lordship see page 47, Your Lordship. An act to augment the resources for meeting expenditure on national security and for public health, and to levy a cess for the said purpose on the machines installed or other process undertaken by which specified goods are manufactured or produced. My lords, will come to page 49, section 4 of this act. Section 4, Your Lordship. There shall be levied and collected a cess from. There shall be levied and collected a cess to be called so and so on the machines installed or other processes undertaken for the manufacture or production of the specified goods referred in Schedule 1 at the amount specified in Schedule 2. My lords will see Schedule 1 and Schedule 2, page 69. Your Lordship. I'll take about 5-10 minutes, Your Lordship. Page 69 is Schedule 1. As of today, Your Lordship, they have notified Pan Masala. Schedule 1, Your Lordship, is the schedule that lists the goods. Pan Masala 2106-9020. Your Lordship will see the page over, page 70. How they calculate the tax liability, Your Lordship. Number of pouches or tins or containers per minute. So up to 500 pouches, if the maximum speed is there, then the tax liability, Your Lordship, is 1 crore 1 lakh. So if suppose, Your Lordship, there are 4 assessees, one having 100 speed, number of pouches, 200, 300, 400, 500. All of them are bracketed into one group to pay the maximum liability of 1 crore 1 lakhs. We tried to calculate, Your Lordship. Is there really a rationale for putting this together? 100 machines, Your Lordship, 100 pouches speed, the actual liability, Your Lordship, comes to 1 crore. His realization itself, Your Lordship, is 40 lakhs. Total realization is 40 lakhs. His liability is 1 crore. So like this, Your Lordship, they have tried to do 200, 300, etc. That's one aspect of it, Your Lordship. We try to find out what is the authority for levying of the cess. We'll also kindly have a look at the constitutional amendments, Your Lordship.
It's good.
Few articles, Your Lordship, I'll refer after the amendment to the Constitution. Page 2, Your Lordship.
Correct, but now.
Yes.
They are seeking the stay of the itself. They'll certainly have to take their stand. And then
Just 2 minutes only, Your Lordship. Just 2 minutes only. Because, Your Lordship, our submission is, apart from the 2 facts which I will point out, the lack of authority and the bizarre of the provisions, the entire basis, Your Lordship, whether they can go by a assumed production when the actual is not there, is now before the Supreme Court. In the capacity based, Your Lordship, which my lords had passed a stay order yesterday based on. So that entire issue, Your Lordship, whether you can assume a production, because entry 84 doesn't provide for it. So whether you can do that, Your Lordship, is pending from 2015 in the Supreme Court. So ultimately, these, Your Lordship, will depend upon what the Supreme Court says. The Supreme Court says no, you can provide for a mechanism by which you can assume a production. Then, Your Lordship, we may have different arguments in this. But the Supreme Court says no, you can't do it. Then all these will go. So I'll just take 2 more arguments, Your Lordship. We'll also see page 3. 246A, Your Lordship. Notwithstanding anything contained in 246 and 254, Parliament, and subject to clause 2, the legislature of every state has the power to make laws with respect to goods and services tax imposed by the union or such state. Parliament has exclusive power to make laws with respect to goods and services tax where the supply of goods or of services or both takes place in the course of interstate trade or commerce. The provisions of this article shall, in respect of goods and services tax referred to in clause 5, of Article 279A take effect from the date recommended by the Goods and Services Tax Council. So entire GST implementation, Your Lordship, will go by what the GST Council recommends. We'll also come to page 11, Your Lordship. (279A), Your Lordship. We can skip, Your Lordship, 1, 2, 3. Your Lordship, see 4. The Goods and Services Tax Council shall make recommendations to the Union and the states on the taxes, cesses, and surcharges levied by the Union, the states, and the local bodies, which may be subsumed in the Goods and Services Tax. So when they want to increase, Your Lordship, from 28% to 40%, if they want to subsume the cess which still was being levied, they can include it as part of the 40% based on the recommendations of the GST Council. So that's how, Your Lordship, this 28% became 40% on the recommendations of the GST Council. That is A. We'll also see the rest, Your Lordship, may not be. We'll also come to F. Any special rate or rates, same, Your Lordship, for F. Thus, any special rates or rates for a specified period to raise additional resources during any national calamity or a disaster. That's how, Your Lordship, when the Kerala floods came, they introduced a cess based on the recommendations of the council. So for any goods, Your Lordship, which are covered under GST today, there has to be a precursor of a GST Council recommendation if you want to levy cess on those goods. If the goods, Your Lordship, are covered both under GST and not under GST, like tobacco products, then since it is not covered, it is also covered under GST, also on the earlier existing entry list. There, Your Lordship, they can invoke the powers of Finance Act, etc., and levy a cess. But if the item is covered only under GST, you have to go through the process of 279A. We could not find, Your Lordship, any other authority for the levy of cess what they are contemplating now. One, Your Lordship. We'll also see the page 10. 271, Your Lordship. Article 271. Notwithstanding anything contained in 269 and 270, Parliament may at any time increase any of the duties or taxes referred to in those articles, except the Goods and Services Tax under 246A, by a surcharge for the purpose of the Union, and the whole proceeds shall form part of the Consolidated Fund of India. So if they want to levy a surcharge and make it as part of the Consolidated Fund of India, they can do it under 271, but that will exclude Goods and Services Tax. And the present cess, Your Lordship, the entire proceeds goes to the Consolidated Fund of India. That's there in the Act itself, Your Lordship. Therefore, it is one submission, Your Lordship, is we don't seem to find an authority for the levy of, for this enactment and the levy of cess on the goods exclusively covered under GST. There is no GST Council recommendation, as, Your Lordship, we see from the Act. They may have a GST Council recommendation, we don't know. But the Act per se doesn't indicate that there is a GST Council recommendation that has been made for the levy of the security cess. Therefore, this levy of cess, Your Lordship, on goods covered under GST appears to be beyond the provisions of 279A. That's the first submission, Your Lordship. The second, Your Lordship, is look at the way, Your Lordship, the tax is being collected. I took my Lord's, Your Lordship, to Schedule 2, where from 100 to 500, Your Lordship, they give a speed and then say 1 crore has to be paid as tax. By the 7th of every month, this 1 crore has to be paid, Your Lordship. Whether I produce that, suppose the machine is only 100, I run for all the 25 days. Even then, Your Lordship, I will not be in a position to recover more than 48 lakhs. We try to do this calculation. You are trying to ask me to pay 1 crore as tax. Why? Because, Your Lordship, this is based on a deemed production. This is not based on an actual production. You collect GST from me at 40% based on the actual quantity which is supplied by me. You know the actual quantity that is being supplied. In spite of it, the cess is being levied on a deemed production too. Therefore, we say, Your Lordship, that this is completely arbitrary. The manner in which they want to calculate the tax. And the third, Your Lordship, is this Cess Act seems to be a replica, Your Lordship, of Section 3A of the Excise Act which they had enacted. 3A also, Lordship, on the tobacco products was based on the deemed production. That is where, Your Lordship, initially it was 2097 they brought it, Your Lordship, 2001 they removed it. And that act, Your Lordship, significantly had an option for the assessee to get back to the actual production. 2007 when they, 2008 when they introduced it, they did not have that actual option. Then we again challenged it. That is how, Your Lordship, my lords will see my compilation. Those notifications were challenged before this court. Page 70, Your Lordship, of my compilation. My lords had seen these orders yesterday. So there, Your Lordship, these three notifications were stayed. Then, Your Lordship, it was all these petitions were pending across the country. The revenue moved a transfer application to the Supreme Court. My lords will say page 73. This is the stay order of the Supreme Court, where the stay is continued. Page 73, Your Lordship. 2015 stay order. And liberty, Your Lordship, was given to the revenue to make an application for modification of the stay. To our knowledge, Your Lordship, it has not been done so far. Then we pointed this out, Your Lordship, on a similar notifications they have done for tobacco products in 25. We had argued this matter, Your Lordship, before the Dharwad bench. The Dharwad bench, Your Lordship, was kind enough to grant a stay. That my lords will see at page 76. Page 76, Your Lordship, paragraph 4. Implementation of the notifications are stayed till the next date of hearing. Of course, we were told, Your Lordship, that we have to continue to discharge the excise duty. As in this also, Your Lordship, all these assessees, Your Lordship, will be continuing to pay their tax at 40% GST, whatever it is, continue to do that. And page 78, Your Lordship, is the stay order we have from the Galburgi bench. I think yesterday's stay order, Your Lordship, has not been. Yesterday, my lords have passed a stay order on the same point. So that also, Your Lordship, kindly see the impact, Your Lordship. Once these rules have been promulgated, all the assessees who have the machines of 100, 200, 300, who cannot afford, Your Lordship, to pay 1 crore, have opted, Your Lordship, for sealing of their machines. All of them, Your Lordship, because the law says by 7th you will have to pay the amount. And if you don't pay the amount, Your Lordship, it becomes an arrears of revenue. And they can't continue to have the impact and say that I have produced only so much, because it's a deemed production. The only option, Your Lordship, is you close your machines for more than 15 days. Only then there is an abatement given or an adjustment given. So at 100 or 200 speed, you continue to work throughout 25 days. You can't have a situation where you can't recover more than 48 lakhs and you are being asked to pay 1 crore. How there could be a justification of this schedule at all? So 3 submissions. 1, we could not find an authority for levying of this, Your Lordship. 2, completely arbitrary. 3, similar, Your Lordship, to the annual capacity rules that have been framed, deemed capacity before the Supreme Court today, Your Lordship. So therefore, my submission is the protection which my lords have given in the earlier matters can continue for us also, can be given to us also, subject to, Your Lordship, the same condition that we will continue to pay the GST at the enhanced rate, Your Lordship.
But firstly, there is presumption of constitutionality, and the presumption and judicial deference is heightened when it comes to economic and fiscal statutes. Article 246A does not divest the power of the Parliament to come out with a levy other than GST. GST is a transaction tax. This is a cess, and this is sector specific. GST is on the supply, but this is on the manufacturing capacity. If your lordship has a look at the preamble of the act.
No, on merits we'll consider.
I will get instructions.
I think I passed some order on the NCCD. Some aspects.
No, my lords have said, your lordship, that excise duty will be payable in addition to GST, and NCCD also will be payable in addition to GST. That, your lordship, was in the tobacco products, which are there in list one.
Here, lordship may, if your lordship gives us some time, we'll complete the pleadings. And having regard to the fact that this will have pan-India effect, lordship may fix a date, my lord, and dispose it off. My lord, I would seriously oppose any grant of any interim relief. Let the petitioners continue to pay taxes. There is the source of power is very much there, right under Article 246A. Even assuming that is not available as an alternative, my submission should be Article 248A read with entry 97. There is no state law on this. So therefore, under the residuary power, the parliament can make this law. On the method, my lord, there I will furnish to your lordships various judgments where Honorable Supreme Court has recognized that the levy need not be arithmetically perfect. It can be based on certain assumptions as well, certain presumptive capacities. There are judgments on that. Kindly give me some time to place those authorities before us.
They're seeking some deemed production capacity.
So the parliament has got a power. My lord, these are all very harmful products. And these are products where the evasion is extremely high. So the act itself is called as Health Security Say, National Security Says. So the object is to as a health security. And levy of cess based on capacity, but there are various judgments, but I'll furnish before. So my respective submission would be, number one, there is legislative competence right under 246A, which 246A does not mean that if you impose GST, Parliament cannot make a law for any other levy. Cess is a different category of levy. So the Parliament has got the power.
Yes, Ms. Shivdas, now matter will require some hearing. At this stage, to grant a stay would be little presumptive.
No, I only two submissions, your lordship. For us, the difficulty is every seventh, your lordship, will have to make the deposit of 1 crore, which is beyond our capacity itself. So that's why we are submission, your lordship. We will file we are already paying GST. We are taking a registration. We are paying GST. We are not going to run away from this.
The difficulty of a petitioner cannot be
that's our difficulty, your lordship, because you give us the liberty, your lordship, to pay the tax after the validity is examined. It's a different point. Today, your lordship, you are asking us, kindly see, your lordship, every seventh I have to pay this. And what is the amount fixed? 1 crore. For what? 100 pouches per minute. I can understand, your lordship, there should be a rationale between the amount being fixed and being asked to pay. You can have a presumption of, say, 20-30%, your lordship, it's understandable. When you have a 500 pouches, your lordship, we worked out. It works almost, your lordship, to the liability that is being asked. For somebody to ask 100 pouches to 1 crore, your lordship, units will shut down. That's all what we are saying. Now, two things, your lordship. My lords had a doubt about the orders passed by my lords. The orders passed by my lords, your lordship. We'll tell you why that order was passed. Same compilation, your lordship. My lords will see entry 84. Page 5 and 6.
So what I'm saying, since now the only way of giving you interim relief is to stay the enactment, which we have to hear and then we have to decide.
No, the union
is heard on that.
There cannot be anything in between.
Yes. The cess, your lordship, in whatever way we look at it, your lordship, is based on the deemed capacity. The cess, your lordship, is on the deemed capacity. It is not on any other method. On deemed capacity, your lordship, we are now enjoying the stay orders of this court, including the stay order of the Supreme Court, on the deemed capacity. If it was any other method, your lordship, it's a different point. The sets itself is on deemed capacity.
On that point, you just get ready. They're saying that there are interim orders on that.
No, those are based on notifications. The notifications have been stayed. Lord, this is plenary law. Lord, which enjoys presumption of constitutionality. And moreover, it's a fiscal statute. It's an economic statute. So where, my lord, as per R.K. Garg judgment, the judicial deference is much heightened. Therefore, let the petitioners comply, my lord, now, and lordship may fix a date, my lord, we'll come back with our pleadings and the authorities, and we'll be ready for submissions.
I'll give you 2 weeks time, you complete whatever you have to.
Lordship, we make it 3 weeks because I have to get the instructions from the policy.
No, our
wing.
difficulty is only 3 weeks, 4 weeks is no problem, Your Lordship. The day after tomorrow, Your Lordship, is our deposit of 1 crore required
Lord,
per
the-
machine. I'll look at it, Your Lordship. 1
Article-
crore per machine.
19(1)G, my lord, is not available for these harmful goods, my lord, the settled principle of
You
law.
can ban the goods, Your Lordship. All that I'm saying is, comfortable, please ban the
The
goods.
state can choose its own method of deterrence. We may not ban, but for deterrence, we can choose the method, the parliament can choose the method.
You're killing industries, Your Lordship. You're killing livelihoods of these companies. You ban the product, it's a different point. But then to have a rationale like this, for 100, you will pay 1 crore, 200 also you will pay 1 crore, 500 also you will pay 1 crore. That's our difficulty, Your Lordship.
No, that's, I get your point, but it's that consequences either the government would have taken note of or is deemed to have taken note of. But stay of a legislation is only
No,
up to.
our only, on deemed capacity, Your Lordship, it would stand on par, Your Lordship, with the other stay orders. Because this liability is only on deemed capacity. The Cess Act, if my lords could see, is only on deemed capacity. It was not on anything else.
On that point, I'll hear. Let us.
Yes, Your Lordship. That's our only point today. As of now, for the purpose of stay is only on that.
No, correct. No, on that point, let them, let them, I'll hear them, let them get their instruct, Mr. Kamath, only on that point. Remaining, it's a matter that pleadings, etc. They are saying that for the purpose of stay, that deemed production is already a subject matter before the apex court. That's what
But
they are
then
saying.
There, my lord, the difference is, it is a delegated legislation, it is a notification. Now here, my lord, it makes a world of difference. The petitioners are challenging a plenary legislation. There is no benefit of a constitutional presumption for a delegated legislation. I am before a lordship placing a very fundamental principle of law that here is a plenary legislation. So therefore, my lord, that argument is not available. My lord, kindly give me 3 weeks time. I will complete my pleadings. Lordship may hear on the legislative competence. My lord, I will come back with the list of authorities as well.
There also, Your Lordship, there was a section 3A that has been, the notifications are empowered through section
No, there
3A.
also the law was challenged. The court did not stay the law because it was a delegated legislation. The notification was stayed. So therefore, my lord, these cases are different.
For the limited purpose of stay, Your Lordship, my lords could hear us next week also will be.
No, my
only
lord,
for
my lord,
purpose of
these
stay.
are, my lord, I have to get instruction
No.
policy wing, my lord. I understand the anxiety,
No, correct.
but kindly give me sufficient time to get ready.
Now, if we were to just see what is the, if interim order is passed, in effect, we are staying the legislation.
No, Your Lord, subject to our, the other thing also is like that only, Your Lordship. There also, 3A read with these notifications, that, Your Lordship, those notifications which indicated we'll have to pay was subject to the fact that we continue to pay excise duty as before.
My lord, I have got one more thing.
Just no doubt, your contention of deemed production capacity is well taken. But here, that provision, if at all, is under this statute, which is again open for challenge. Now, if we don't know what will happen in that, but here.
That's right, Your Lordship. If there, Your Lordship, the Supreme Court says.
I have one submission to make. My lord, the submission that the petitioners should be granted protection till the validity is upheld is directly in contradiction with the settled principle that there is a presumption of constitutionality. He cannot say that first you prove your constitutionality, then I will pay. No, that's absolutely contradictory to existing settled principles.
Let the pleadings be complete, Wills. Lord Senior Counsel has raised various contentions attacking the validity of the health security SC National Security Cess Act 2025.
That is health security, say national security. That's a Hindi word.
That Hindi SC, Your Lordship.
It is not SC.
In fact, Your Lordship, I asked my people, is that a mistake in the writ petition that you have always says SC everywhere? When we looked at the act, it is still a say, Your Lordship.
The third senior counsel, Shri Shivdas, has also contended that the deemed capacity that is taken note of may not stand legal scrutiny and relies on the interim orders passed in other matters as regards notification with respect to deemed capacity. However, the EST appearing for the central government submits that the legislation by itself, validity of which is questioned, is a matter to be decided and consequences would follow, but opposes for any interim order stating that the same would be in the teeth of a presumption of constitutionality of legislations. This matter requires consideration, pleadings to be completed at the earliest, relist after
3 weeks. 3 weeks. I'm great.
the week commencing from 2nd of March.
Date. End of the month.
Which date, sir?
Second of March.
Second of.
21.
I'm second of March, just not.
Third of March. Week, list on 3rd of March. Yes.
Great, French.
21. Lakshmi Menon.
So this is a GST matter, my lords, where the petitioner is a concessionaire with entered into a concession agreement with NHAI. My lords, the show cause notice, my lords, at page number 32 is for a consolidated show cause notice. The period 1819 to 2223. The tax period is mentioned at page number 32 from April 2018 to March 2023. My lords, in a sister concern, this is relating to road works from Bairapura to Chellakere. Sister.
That is still pending.
Still pending. It is actually getting listed tomorrow.
In light of the contention that the show cause notice, the single show cause notice has been issued for multiple tax periods. That is from April 2018 to March 2023. And that such a contention has been noticed and relief granted by the coordinate bench. In WP?
In Pramur Homes, my lords.
In Pramur Homes and
Centers.
So there will be an interim order of stay of
Annexure A3 and A4.
Annexure A3 and A4.
A4.
Pramur Homes and Shelters versus Union of India 2024.
WP 33081, my lords.
168 taxman.com 12 Karnataka. Arvind Chauhan accepts notice for the respondent.
My lords, the citation is 181 taxman.com.
Yeah.
I've annexed it with the my petition.
Let's see, that's the mistake.
Please.
But in the earlier matter, we're taking notice for one. The earlier matter, constitutional value. Serial number 20.
20, Arvind Chauhan accepts notice for the respondents. DSG appears for the respondents.
22. Uday Shankar R.
For the petitioner, my lords. My lords, the petitioner conducts work contracts for government agencies, including for BBMP. Sometime in June 23, a show cause notice came to be issued seeking payment of GST relating to a period which was pre-GST, my lords. The petitioner could not reply to this show cause notice, and an order came to be passed on 24th of November 23, which is at Annexure A. Even before this order was passed, the personal hearing the petitioner could not attend. That's because, my lords, what happened was due to his financial problems, he attempted suicide first in August 21, and thereafter on February 23, 24th February 23, my lords,
And he was unable to actually reply to the show cause notice and also be present for the personal hearing, basis which this order dated 24th November 23 came to be passed. I have presented the discharge summaries of both the dates, my lords, for 21st August and February 23, which is at page number 40, where he was in the hospital for about 55 days, my lords. Page number 71, my lords, is the second time when he attempted suicide, which is on 24th of February, discharged in March 4th, 2023. Page 71, my lords. Thereafter, he was basically incapacitated and disabled and was not able to attend to his regular work as he was wheelchair bound. Page 71, my lords, is the discharge summary. Thereafter, right up to November 2024, he was under medical supervision. All those medical reports I have placed here, my lords. The impugned order, my lords, Annexure A, shows that he was not present for the hearing.
I will
Which
not
is that-
object. I will not object, madam, because the tendency of suicide and COVID-19 impact is so high. I don't want to interfere, but I'll request, my lord, the date of hearing may be fixed and let them should not escape.
I will cooperate, my lords. Even if it's a time-bound issue that needs to be done before the department, I'm willing to do that.
There is no escape from tax.
I most unequal, this law means tax.
Tax is like death, my lords. Certain.
Petitioner has called in question the validity of order of adjudication at Annexure A passed under section 73(9). It is case of the petitioner that the order passed is on the principle of best judgment assessment.
Yes,
as the petitioner did not make out any reply to the show cause notice. The reason assigned by the petitioner is during the relevant points of time when personal hearing was afforded, petitioner was incapacitated due to his medical condition. Reliance is placed on medical records at Annexure.
Medical records are at Annexure D and F, my lords.
At Annexure D and F.
D, E, F, my lords.
Huh?
D, E, F.
D, E and F. The counsel for the petitioner submits that taking note of his medical condition and recovery, seeks for reopening of the proceedings with opportunity to the petitioner to enable the petitioner to take his stand on merits. Third, HCGP submits that the authorities were constrained to pass an order due to absence of any reply to the show cause notice by the petitioner. Heard both sides peruse the medical records at Annexure D, E and F. The said medical records are self-explanatory. Notice that the order of adjudication is passed without benefit of any reply on merits to the show cause notice by the petitioner. Order is passed on the principle of best
Show cause
judgment
notice ಹೇಳಿ.
assessment. In the peculiar facts of this case, it would be appropriate to enable the petitioner to take a stand by way of reply to show cause notice and enable the petitioner to participate in the proceedings. In light of the discussion made above, an order at Annexure A. A.
My lords, annexure A, annexure G is the criminal proceedings that have been initiated under section 79, my lords. Annexure
For
G
recovery
page,
of amount, my lord, that may be quashed and remitted matter back to the, at the stage of show cause notice. The show cause notice is annexure B at page number 22, my lord. 18/5/2024, my lord.
no, that is the next one.
Alva, nim reply na?
The next one. ಇಲ್ಲ ಇದು next serial number ನೀವು ನೋಡ್ತಾ ಇರೋ
18/5, my lord.
show cause notice is at annexure B, my lord.
Annexure B, correct, my lord.
Order that annexure A is set aside as well as the recovery proceedings.
Annexure G, my lord.
G.
In case number
153 of 2025.
C/M 153 of 25 pending before the Court of Special JMFC within bracket sales tax Gandhinagar at annexure G series. Matters remitted to the stage of reply to the show cause notice at annexure B.
Yes, my lord.
All contentions are kept open. Petitioner to appear before the first respondent without further notice on. Needless to state, the petitioner fails to avail of opportunity granted by this court on the date fixed. The indulgence granted by this court would stand withdrawn. Mail HCGP accepts notice of the respondent. Petitioners.
Same order may be
Same.
Yes.
23 also, my lord.
Same.
Same order.
So the next
One
one
is high, my lord.
Annexures.
Annexures will remain the same, my lords.
Same.
Same. The criminal proceedings number will be 150 of 2025.
So the order at annexure A.
My lord, annexure A is the adjudication order, my lord. Date will be changed, my lord, 24/11/2023. And annexure G, criminal petition number is 153 of 2025, my lord.
150.
3.
150. The 153 is the previous one, my lords. This one is 150.
So the annexure G.
ಎರಡು petitions ಇದೆಯಾ?
150 of 25.
Sorry.
C/M 150 of 25. Order of adjudication at annexure A. Same order, same date.
Great one, my lords.
24, serial number 24, comment.
The petitioner is challenged an ex parte order passed under the GST Act, Your Lordship. The petitioner is a government enterprise. The show cause notice that was issued had gone unnoticed, Your Lordship. I humbly request that
Order
if the
of
matter may be
adjudication at annexure.
annexure A, Your Lordship, page number 17.
Annexure A is the impugned order, my lords.
No reply.
No reply has been given. Personal hearing also we have not appeared. They've stated that they have served the notices for personal hearing by email, but we are not able to trace those emails. And the show cause note, the order also we were not aware until the recovery demand notice was issued. And the petitioner received calls from the department saying that there is an order passed and the recovery proceedings will be initiated. The demand is huge, Your Lordship, and because of certain changes that had happened within the petitioner's company, therefore the.
Correct, you're all government organization.
Yes.
You should have a system in place.
Yes.
It can't be
Yes.
so sporadic.
Yes, Your Lordship.
Page
Firm steps have been taken now to regularize, Your Lordship. It's a huge demand which has been levied. And also on the merits, Your Lordship, what has happened here is they have charged GST on the advances. This is 17-18 tax period. So on the advances, all the projects which the petitioner has done is for BDA, BBMP. Now, there are certain exemption notifications which are available to the petitioner for these supplies, Your Lordship. So even on merits, we have a good case, and if given a opportunity, we will place on record all these responses, Your Lordship. And a part of the turnover, VAT also has been discharged. And on the same turnover, GST is also proposed to be levied. A date can also be
My lord,
fixed for the.
think page number 24 for a moment.
Otherwise, she is more vocal.
24, my lords. Lordships may kindly come to para 8.2. There it shows, my lord, the opportunities given, notices issued, the date wise he has referred to the officer.
Read some lapse on this.
Then your lordship may kindly come to 10.1.
Yes.
It is not that they were not aware of their liability. They have discharged the part of a liability. Well, this is a remaining part because they undertake, my lord, a big contracts that is to be entrusted by the other agencies of the government. This is a government undertaking. All road construction, layout construction, all other infrastructure facilities, etc. So the amount is not naturally involved is a very huge amount, and this is a works contract service. Well, they have discharged the part of the liability on receipt of advances. Now, my lord, remaining part, my lord, they have not. This was found out during the course of an audit. Now, my learned friend cannot say that we are exempted.
You must have a system in place.
Yes, Your Lord.
Since my lord, the demand is very huge. If they are able to, my lord, make some reasonable deposit for an interim order,
Your
that
Lordship,
would be a my lord.
that is not possible in this case, Your Lordship. It's a huge demand on which we are even contesting the authority and jurisdiction to make this demand. Your Lordship, my instructions are that for all of whatever notices that this petitioner receives, they issue a tender for appointing an auditor, either a chartered accountant, to give a reply. And during this point in time, because of change in officers, the CFO also had changed. So because of various other reasons, they have not been able to take note of what has happened. But now instructions have been given that once a date has been fixed.
Right, but that's okay. But Jeevan is saying part of it you have discharged.
You'll also, an opportunity may be given, a date may be fixed, a timeline.
We will, but he's saying finally it's you have to bear that minimum whatever that is.
If they had gone in appeal, my lord, 10%. That was the, my lord, the minimum.
Also, this is a case where we have challenged the
When they accept the
jurisdiction and
liability,
authority to levy
now,
the
my lord,
tax.
once they accepted the liability, now it is only a quantification.
Lordship, we have not accepted the liability merely because certain payments have been made. That doesn't mean that the tax quantification is accepted.
No, I am saying that quantification is disputed.
The
Liability is
levy
accepted.
authority itself that is disputed. All these projects are for BBMP and BDL Lordship. All these are for government projects. There are no private entities.
Called in question the correctness of the adjudication order at annexure A.
First time it is coming, lost my grant an interim order, then next time we'll get
At annexure A, it is submitted that proceedings have culminated in an order passed ex parte. The non-filing of reply to show cause notice is stated is due to reorganization of the staff.
Yes.
Huh?
Yes, Your Lordship.
Staff.
And also because they had not received any hard copy of the notices, Your Lordship.
And due to certain.
And it was only uploaded on the GST portal.
And due to.
When we serve hard copy, that is not a normal mode of service.
Lordship, there are
the
several
portal,
decisions.
And the notices issued did not come to the attention of the concerned. So it submitted that the nature of liability itself is huge and an opportunity be granted to participate in the proceedings. It's also submitted that the undertaking is the government of Karnataka undertaking. Third Council G1 requests time to take instructions. In light of the contentions raised. There would be stay of.
Annexure A, my lord.
Stay of
Annexure
annexure
A,
A and proceedings for recovery till the next date. This is the matter. G1 accepts notice of the respondents. This is the matter in the preliminary hearing list. 17.
25, Srihari.
Appearing for the petitioner in this matter, the impugned order is at page, is at Annexure D, page 38, my lords. The petitioner had filed an application seeking to amend the address of the principal place of business, my lords. A few responses were filed and order was passed, my lords. The order, the respondent number 1 does not assign any reason, says that the reply has been examined and the same has not.
It's only the amendment, is it?
Yes, my lords. Amendment, there are 2 prayers. My registration has been cancelled, my lords. Thereafter, after passing this order, he issues a show cause notice, my lords, at page Annexure F, page 41, my lords.
What are the main proceedings?
Main proceedings, my lords, to say investigation is going on. That will have to secure instruction as to what has happened to the main proceedings.
So what is the amendment now?
Amendment is to the address of the principal place of business.
Your lordship, see, annexure C2, my lord. The amendment sought is principal place of business. We have issued a notice for hearing or reply saying that the attached document does not clarify the area schedule ABC, which is taken on rent. The document depleting the owner or GPA holder vendor may be submitted. They have not submitted any reply or this thing, my lord. Hence, they have passed an order for cancel. That is rejection of that amendment, seeking amendment of place of change of principal place of business. If they had filed a reply or given a document saying that what is the place of rent, which is the schedule, where, what is the door number, all those things, then he would have considered it.
All we are requesting is for one more opportunity, my lords. Even the after this passing this order, I've issued a show cause notice, my lords, for cancelling my registration. That, my lords, can find it at page 41, Annexure F.
Yes, sir.
I'll leave it to your lordship.
We'll send it.
Send it post show cause, that is for this
reply to
this annexure C2, my lord.
Reply to
annexure C2.
Annexure C2 and F, my lords, because my registration has been cancelled now.
Annexure C2 is a notice issued by the department.
So they have to reply to C2.
C2.
And my lords, the other prayer is with regards to cancellation of my registration, my lords. The show cause notice is at Annexure F, my lords, page 41. Sufficient time was not granted, my lords. It was issued on 7/3/2025. I was asked to file reply within 11/3/2025, my lords. 4 days time was given.
No, now this F is consequent to C2. Huh?
Maybe once the place of business is not available, my lord, that is why they have initiated anti-evasion letter. There was a letter issued by the anti-evasion on 6/3. Hence, show cause notice was issued that when he does not have principal place of business, how is he going to conduct the business? Right? Both the things.
F can be kept in abeyance till C2 is decided.
Yes, please, please. Huh? Or else G is the order of cancellation, my lord.
Yes.
G can be set aside and remanded back to the F stage, my lord. Both the matters. In the earlier stage, it can be remanded to C2, my lord. So that would suffice. And a date can be fixed, my lord, where they
the petition. Yes. Calling question. The validity of order at annexure D, whereby application of a petitioner for amendment has been rejected. The application for amendment relates to change in the principal place of business.
Yes,
Petition petitioners also sought to set aside cancel of registration at annexure F. Full stop. The show cause notice for cancellation of registration at annexure F. The show cause notice calls upon the petitioner to explain as to why registration cannot be cancelled on the ground that the person, inverted comma, person does not conduct any business from declared place of business / place of business not found. Those are noted. In the case of the petitioner that eventually registration has been cancelled as per the order at annexure G, and the same also has been assailed. Petitioner submits that the order of cancellation of registration at annexure G appears to be connected with the proceedings initiated as reflected in the show cause notice at annexure C2.
Yes, ma'am.
C2.
Yes, ma'am. C.
It is submitted that the petitioner may be permitted to make out a reply to the notice. Which is that notice now? Before C2, is it?
C2, my lord, it should be maybe remanded back to C2.
But C2 is a notice seeking additional information clarification. What is the proof of place of business?
Correct.
So if he can provide anything,
He'll
then
submit evidence.
Notice at annexure C2 whereby information was sought regarding principal place of business. Next. Taking note that the petitioner's registration has been eventually cancelled and the same are linked to the doubt expressed by the revenue regarding principal place of business. It would be appropriate and meet ends of justice by remitting the matter back to reply to notice at annexure C2.
dated 13/9/2024.
Dated 13/9/2024, which relates to the principal place of business. Further, it appears that the proceedings for cancellation of registration are in connection with the subject matter of the proceedings at notice at C2, and accordingly the order at annexure G is set aside and matters remitted to reply to the notice, show cause notice for cancellation of registration at annexure F. Petitioner to be present before respondent number.
Respondent number 1, my lord.
1.
Yes, my lord.
And make out his reply to the show cause notice at annexure C2 as well as the show cause notice at annexure
F.
All contentions F2. Which one accepts notice for the respondents.
C2, the
C2.
date is 25/9.
Which one?
C2. Date is 25/9/2024.
25/9/24. There are two dates.
Yes.
25/9/24. Yes.
26.
My lords, with my lord's permission, I appear virtually.
Yes.
My lord, this is a writ petition challenging reassessment in relation to assessment year 21-22. I will demonstrate to my lords that the 143.3 scrutiny assessment was done on the very same issues. My replies were pointed response to queries raised. Now in the second round, they want to reopen this as reassessment, which is just change of opinion, which is not permissible because it amounts to review. My lords may kindly first have page 56, my lord. This starts from, in a sequence I'll show, kindly see this starts from page 54. This was the response I filed in the original assessment proceedings. to a show cause notice issued to me. Kindly turn to page 56. These are the 4 items on which pointed queries were raised. I gave my response. Then kindly turn to what was the TDS, etc. Item C is the issue in hand on page 56. Now, if my lords will kindly have the assessment order under 143.3, which is at page 121, annexure N. The important thing to note here is, my lord, they received in the para 1, verification report was received. This is their internal process where they verify, identify issues. This will be clear if my lord turns to the next page, where what they wanted to assess was non-deduction of TDS. That was a focused inquiry. And after considering my entire response, they passed an order, making some additions, whatever. That was in 143.3 order. Now, my lords, I receive a notice under 148, which my lords will find at page 32, annexure A, impugned notice. Again, asking the very same 4 on page 33, my lords will see again the same 4 issues are there. They want to re-examine it. (32) is the notice, 33 is the annexure, where details are asked for the very same transactions.
So 56 and this 33, you're
Yes,
seeing
my lord.
same.
Yes, my lord. 56 was in the original proceeding. 33 is the current proceeding, impugned proceeding before my lords. After 56, they passed 121. Considering my reply.
Okay, let us see matter request.
Your Lordship, no, my lord. Your Lordship, my learned friend is arguing as if it is a old 148, my lord. Now new 148 has been inserted. Your Lordship may kindly come to page number 32, my lord. Notice issued under section 148A1. Your Lordship, as per this notice, my lord, he is required to file reply. The information has been provided in page 33, annexure. In respect of 4 transactions, my lord. Your Lordship, first 4 transactions, this is the information what we have got, and on the basis of it, notice has been issued. For this one, my lord, reply has been filed and order has been passed, my lord, at annexure B, page number 35. Your Lordship, this is the order which is impugned here in writ petition, my lord. Your Lordship may kindly come to page number 37. The 4 transactions have been extracted in tabular column. As far as the first transaction, my lord, Cisco Systems GK Japan, the first transaction, and the last transaction, multi-lane offshore side. These 2 transactions have not been accepted. The assessing authority giving reason at page number 38. Your Lordship, he accepts the other 2 transactions. In respect of the first transaction and the last transaction, he says the 3rd line in page number 38. However, in regard to transaction undertaken with Cisco Systems GK Japan for an amount of rupees so and multi-land offshore an amount of rupees so the assessee has failed to prove it. The documents with the TDS provisions are not applicable. Thus, the assessee has failed to deduct TDS under page number 38, my lord, in the first paragraph. Page number 38, the reasoning of in the impugned order. Yes. As far as these 2 transactions is concerned, the assessing authority, the assessee has not provided sufficient documents, therefore it has been rejected. Now, after this, Lord, the assessing authority has to continue the proceeding.
Just now, yes, this 2 items.
Yes, Lord.
29657,393.
Yes, Lord.
And that multi-lane offshore.
Yes, Lord.
So part of the assessment order.
Your Lordship may kindly say after 1/4/2021, the entire system of reassessment procedure has been changed. Your Lordship may kindly have section 148A. The information what the assessing authority is having, on the basis of that, I have to issue notice. The information what I get from risk management cell, what?
Correct. Can you?
Your Lordship, there is no change of that concept. Is everything has gone now. Earlier, my lord, under section 148, there should be reason to believe that itself has been removed.
Forget that. Finally,
yes,
it's a principle
that
you can't revisit something which you are adjudicated.
Your Lordship.
Now, that was the underlying. change of opinion was not a ground, it was a principle, isn't
Your
it?
Lordship, that is not, Your Lordship, change of opinion, it was there, my lord, in 148. Your Lordship may kindly see the earlier 148, there should, the assessing authority has to record reasons and reason to believe should be there. Everything is removed. What is now the present one? Your Lordship, 148A. The basis of info, only on that basis of information, whatever I get from the risk management, I can initiate. I don't have any independent authority or power. Your Lordship, may I read 148A, my lord.
How can you vex somebody 2 times?
Your Lordship, this is the law, what is now, Your Lordship, 148A. A procedure before issuance of notice under section 148, where the assessing officer has reason, has information which suggests that income chargeable to tax has escaped assessment. In case of an assessee for the relevant assessment year, he shall, before issuing any notice under section 148, provide an opportunity of being heard to such assessee by serving upon him a notice to show cause as to why a notice under section 148 should not be issued in his case, and such notice to show cause shall be accompanied by the information which suggests that income chargeable to tax has escaped assessment in its case for the relevant assessment year. What is that information? That is explained in the explanation, my lord. Explanation to this 148A1. Your Lordship may kindly come to the amended, pre-amended, my lord.
No, correct. Now, this is a legal question.
Your Lordship, that is, Your Lordship, there is also judgment, my lord, which says that the assessment has to continue since the information, my lord, on the basis of which it has been taken. Now the assessee has not submitted two documents in respect of two transactions. He has to produce it in the regular course.
No, let us see. We'll examine.
Your Lordship, this citation just I'm laying upon, my lord.
May I only draw my lord's attention to one decision by Honorable Justice Vibhu Bakru sitting in Delhi. My colleague will hand over that. Kindly see exactly on the point. This is a decision of 21st of May 2025, page number 1. My lords will kindly see, kindly turn to para 10, para 11, my lord. Reason and conclusion. Explanation 1 to 148 is considered. I am reading only relevant page, paragraph portion in para 5, page 5. The AO in effect, this is about 5 lines, 6 lines from the top, my lord, on page 5. The AO in effect held that it was permissible to revisit the issues examined during the assessment proceedings if an audit objection to the effect that assessment has not been made in accordance with the act was raised. The question whether assessments can be reopened on the basis of audit observed without notwithstanding the issue of having been examined threadbare by the AO is a central controversy to address in this petition. The petition also contends that the impugned notice. This I will skip, my lord. Kindly come to para 22. Here the court gives its finding. Para 22. Undeniably, this would be a case of change of opinion. If the said amount is now held to be chargeable to tax under the act, we must at this stage note that there is no cavil that the exercise initiated pursuant to impugned notice is for all intents and purposes an attempt to review the decision of the AO in the assessment proceedings. However, it is contended by revenue that the same is permissible as the initiation was triggered by audit observation. The same constitutes information that can trigger reassessment. We find no merit in the contention. I have attached Bombay High Court decision, and therefore, but I am not troubling my lords because this is the principle that a High Court is saying, a coordinate bench of the High Court. Interpreting the new law.
Let us see, it requires consideration. Nageshwar Rao is very strategic.
Your Lordship may kindly see, he has not provided
On a
it.
lighter note, Nageshwar Rao is very strategic. He has given one checkmate.
My apologies, my lord. I only.
So he's saying chief judgment, you can do what you want.
Your Lordship, in my case, what I have relied upon.
Apology,
in my case, what I have relied upon, my lord, High Court has held in our favor. SLP is dismissed.
Let us see.
Please.
The counsel for the petitioner submits that the present notice under 148A at annexure A attempts to review and revisit adjudicated aspects which were part of the assessment proceedings considered in the
Annexure
order,
N 29/12/2022.
in the order passed at annexure
N, my lords. N for Nageshwar Rao.
Page
Page 121,
in the
dated
order of
29/12/2022.
assessment order, dated
29/12/2022.
29/12/22 for the relevant assessment year of 21-22. Full stop. The learned counsel Shri Sanmati would submit that in light of the amended section 148 capital A, the question of change in opinion sought to be relied upon cannot be invoked. Full stop. Learned counsel appearing for the petitioner relies on the order of the Delhi High Court in WP 336/2025 rendered on 21/5/25 and submits that the aspect of change in opinion and review being impermissible once decided is an aspect that requires consideration even under the new provision. Full stop. Subject to further consideration, there would be stay of
A, B, C, D, my lord.
Annexures A, B,
C and D.
Statement of objections to be filed. Release the matter after 2 weeks. Please.
Obliged to my lords.
It is a case where we are seeking a remand.
Yes.
What has happened is the SSC PAN was originally in Bombay, my lords. Recently, he suffered a injury and passed away. The reopening 148AA was issued. He filed a reply stating that he has bought one house which is out of a loan. Thereafter, he could not reply. He was incapacitated. The order has now been passed. Now, my lords, if I may just the PAN of the SSC is now linked to his legal heir. I just point out, my lords. This was done in September 25. My lords may see the left-hand top corner, YB Nandini. If my lords were to come down to the middle of the page, it says representative SSC, and then thereafter down below, Dayanand Donappa. Dayanand Donappa is the deceased SSC. And YB Nandini is his spouse. We have filed the petition as legal heir. Now, what has happened is there was a question raised whether the maintainability was there. So I just addressed that first. This is a curious case where the lady Ella is a resident of Davangere, so she will fall under the jurisdiction of this court. Now, insofar as ITA or regular appeals, jurisdiction of the assessing officer will be admitted. But now, since she has linked the PAN, the officer has to pass an order on the legal heir, and it would be the jurisdiction officer at Davangere. So my humble submission is, in the peculiar circumstances of the case, I am praying that it may remand it back to 148 AB stage so that the SSC can file details. The only transaction is a house bought in Bombay in 2015-16, and I have filed a reply. I'll just point that out, my lords. May I take my lords to page 107. This is the reply filed by the SSC when he was alive. I just read out, my lords. My lords have 107. I have purchased a flat at Kharak sector 15. Out of 50 lakhs, 1 lakh and 9 lakh were paid through check dated so and so. ICICI Bank, the other check number so and so, dated so and so, drawn on HDFC Bank, Kharagpur, with 40 lakh loan from Indian Bank, and also paid all tax including SIDCO transfer charges. Documents attached for your reference. So I filed a reply saying that for 50 lakh, I have taken a 40 lakh loan. This is beyond 3 years. It should have been dropped technically. But the information which my lords will see at 148 AB, page 39, was a duplication. My lords may take to page 40. There is a table. The information, AR information, has been provided twice. In my case, I have bought only one property. Sanat Kumar Murli will apply. But still, since I could not reply thereafter, I am saying let it go back to the stage. I will file details of this purchase, and this purchase deed was already filed. If they have details of 2 transactions, then that will be another issue. But I have given status that I have already taken a loan. I am only praying let it go back to the stage of 148 AB reply, and the jurisdictional officer is respondent 1. After I made the change, I have made the respondent one as the jurisdictional respondent one of the current LR. We will file a physical reply, my lord.
So the reply will be to the same A. Now this will transfer.
Yes, my lord.
The petitioner has 159.
159, my lords. One 159 2B and C.
So the jurisdiction will be that of the legal representative.
Please, my lord, please. Anyhow, they had to pass it, but since I have registered, the order would still be passed in her name only.
The petitioner has called in question the validity of the notice under section 148 capital A small b as well as order under 148 capital A small d at annexure A1 ಮೇಲೆ A ಅದು as well as 148 notice at annexure A2 comma unsigned sanction order at A3 order under 147 at A4 penalty order at A5 penalty order at A6 and A7. Full stop. In the case of the petitioner that no reply was made out to 148 capital A small b at annexure A that the information that is referred to refers to two sales of 30 lakhs which is contrary to facts that the petitioner has purchased only one property with a loan. However, petitioner submits it was not possible to reply to the said show cause notice due to bona fide reasons. Full stop. It is noticed that after the death of Dayanand Donnappa, his legal representative has been registered as a representative and such a fact is not controverted. Full stop. In light of the 148 AD order being passed without reply to 148 capital A small b notice, it would be appropriate in light of the contention of the raised by the petitioner that he had purchased only one property by taking loan to set aside the order under 148 capital A D and remit the matter back to the stage of reply to 148 capital A small b. Full stop. Note though the 148 capital A small b notice at annexure A is issued by the jurisdictional assessing officer at Mumbai. However, in light of his death and the pan of the light of his death and pan of the dead SSC now being linked to that of the petitioner as a representative SSC, it would be appropriate to direct the petitioner to appear before the jurisdictional assessing officer at Davangere.
Please, respondent
number 1.
That is respondent number 1 and make out reply to 148 capital A B notice. All contentions are kept open. Petitioner to appear before respondent number 1 without further notice on.
The lordships may kindly fix after 10 days in.
Now what else has to be set aside?
My lords, annexure A1 to A7, my lords.
Annexure A1 to A7 are set aside, matters remitted.
My lords, a small note may be stated that the notice under 148 AB may be deemed to have been issued by the respondent one. Because
The
originally,
notice under 148 capital A small b will now have to be deemed to have been issued by respondent number 1 in light of the death of the petitioner of death of Dayanand Donnappa and the petitioner having registered PAN as a representative SSC.
yes. Keep the
28, that is Rajan Reyes.
This is appeal for the petitioner counsel, my lord.
For the caveator respondent
The-
6 months.
The point for the consideration in the present petition, my lord. But I am the land loser for the benefit of the Kempegoda's left. Extent of 1 acre and that is 1 acre to 8 guntas. In pursuance of it, a consent award is passed. Lakshmi Kind annexure C may be kindly be seen, my lord. Page 25. In the awards to an extent of 11,500 square feet. An allotment is made in favor of me by virtue of the allotment letter dated 30th/6/2023, annexure D. Your Lordship, page 28. Your Lordship, kindly see the subsequently, my lord, for the reasons the respondent here in the BDA, annexure E, they in spite of have not given any representation. Unfortunately, they have taken this same site 3305 has been allotted in favor of the present sixth respondent. The similar issue has been in a connected writ petition is raised. And they pay in the WP, the Your Lordship kindly, that is pending, the Your Lordship has stayed the allotment letter in WP 3919 of 2025. Your Lordship kindly, the same allotment letter dated 23/12/2005 stayed by the Honorable Court in WP 29, the WP number 3918 of 2025.
Now that is the allotment made to the private respondent.
Exactly.
Yes, has been stated.
Oh, in fact, he not the now here my allotment in 2023 without cancelling my allotment. Now there is an allotment in favor of the sixth respondent. That is bad in law. That is my submission, my lord.
My only submission
This repetition is pending consideration. That
we
matter.
have to issue notice and tag it.
Yes, it may be tagged, my lord. I have no objection for tagging them.
You appear for?
Respondent number 6, my lord. Caveator respondent number 6.
Appear for respondent number 2 to 4, my lord. I am directed to take notice. My lord, I will take instructions, my lord. Your lord.
Correct, but now at annexure E, there is a statement that you have requested.
We have not made any such representation. They themselves, same day, such a representation is created and say an announcement is made in favor of the sixth respondent. A reply is also given to me. There is no such, surprisingly, I am shocked. Such a representation is given. How the BD,
Just,
I made a reply also.
Just along with WP 39198 of 2025. Yes.
In the meanwhile, I may be permitted to file my objections.
Annexure F may be kindly be stayed. Same order may be kindly be passed.
No, no, it's already stated.
It is already stated.
Statement of objections to be filed by the other side.
29.
Your Lordship, in this case,
Then office objections. Office objections to be complied with. ಅಷ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ. Office objection is yes.
Your Lordship, in this case, we have filed 3 refund application, the details of which can be seen on page number 9.
They have not taken any action, is it?
Yes, Your Lordship, we have filed 2 refund application in the year 2013
and one refund application in the year 2015. Till now, the refund application have not been processed.
Eight. Central tax.
I'll take notice.
Arvind Chauhan accepts notice for the respondents. Is the matter in the preliminary hearing list after 10 days date code. Office objection to be complied with in the interim.
30, Manohar HP.
Your Lordship, a date may be fixed for hearing.
We have given that.
18.
18.
Serial number 30, Manohar.
Please, Your Lordship, I appear for the petitioner in this matter, Your Lordship.
Yes.
Your Lordship, this basically reassessment orders under Karnataka VAT Act was passed for the assessment years 2008 to 9, 9 to 10, and 10 to 11, Your Lordship, in the year 2015, 16, and 17, respectively, Your Lordship. After that, Your Lordship, recovery proceedings were initiated. In fact, I was not served with the reassessment orders, Your Lordship. That itself is mentioned in the reassessment orders that I have not been served. Then recovery proceedings were initiated, Your Lordship. Then I came to know through the bank that these proceedings are going on against me. Then I preferred a rectification application before the authority, Your Lordship. It came to be dismissed, Your Lordship, without any hearing. Then I preferred an appeal, Your Lordship, against before the first appellate authority, Your Lordship, and that is still pending, Your Lordship. In meantime, the coercive steps were taken and my bank accounts were seized, Your Lordship. And Your Lordship, after that, I preferred a writ petition before this Honorable Court, Your Lordship, wherein the court dismissed, Your Lordship. However, it gave me liberty to prefer a stay application in the memorandum of appeal proceeding.
Just one.
And
We'll just 1 minute. We'll
please
continue at 2:30. We'll continue at 2:30.
Very well, Your Lordship. Very great.
Kind permission, ma'am. Serial number 45 is nice matter, ma'am.
ಇಲ್ಲ ಅದೆಲ್ಲ ಒಂದ್ ದಿವಸ ಬರ್ತಾ ಇದೆ ಮಂಡೇ ಬರ್ತಾ ಇದೆ ಕೋರ್ಟ್ ಮುಂದೆ ಮಂಡೇ
Court officer, sir? Court officer, sir? Court officer, court officer, court officer.
Tell me, madam. Hello, ಹೇಳಿ.
ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 24 ಅರ್ಜನ್ ಆಗಿದೆಯಾ ಡೇಟ್ ತಗೊಂಡಿದಾರಾ ಸರ್? ಲಿಸ್ಟ್ 1 ಸರ್, ಸಾರಿ ಲಿಸ್ಟ್ 124 ಸರ್, ಸಾರಿ ಸರ್, ಲಿಸ್ಟ್ 1.
List 124, not yet called, madam.
Not yet called out. Okay sir, okay. Court officer, list number 2, serial number 52, ಬೆಳಿಗ್ಗೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿತ್ತು ಟು ಬಿ ಟೇಕನ್ ಅಪ್ ಅಟ್ 2:30. ಅವರು ಜಡ್ಜ್ ಅವರು ಸಬ್ಮಿಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳಿದ್ರು 2:30ಗೆ ಕಾಲ್ ಔಟ್ ಮಾಡ್ಲಿಕ್ಕೆ.
Please wait, madam. Another court officer will come.
Okay sir, okay.
I will inform him.
Yes sir, list number 2, serial number 52.
Okay, madam. Yes.
Is to 230.
May please, Your Lordship.
Yes.
Your Lordship, this is the case where reassessment orders under Karnataka VAT Act were passed in the year for pertaining to year assessment year 2008 to 9, 9 to 10, and 10 to 11 were passed, Your Lordship. The assessment orders were not served upon us, which is explicitly mentioned in the reassessment order itself. And pursuant to that, Your Lordship, the notices were sent to the banks where I hold account. So from the bank only, I was got intimated about these proceedings, Your Lordship. Immediately, I preferred a rectification application before the authorities, Your Lordship, which within 2 days they have dismissed it, Your Lordship. And immediately thereafter, I preferred an appeal before the first appellate authority, Your Lordship, which is still pending, and no communication has been given to us, Your Lordship, whether the proceedings are happening or not. We don't know about it, Your Lordship. The same was preferred in the year 2022, Your Lordship. Then after that, Your Lordship, I preferred a writ petition before this honorable court, Your Lordship, against the freezing of the accounts, Your Lordship. Notice against the stay of section 45 notice, Your Lordship. This writ petition came to be dismissed, Your Lordship. However, the liberty was given to approach the concerned authority with a stay application, which may be considered in accordance with the law, Your Lordship. And in the February 2025, Your Lordship, I preferred the stay application, Your Lordship. It has to be considered within 30 days of period, Your Lordship. It's a deemed clause is there in the Karnataka VAT Act, Your Lordship. Even it's almost a year, Your Lordship. My application has not been here, Your Lordship. One more thing, Your Lordship. Simultaneously, criminal proceedings are initiated against me, Your Lordship, under Section 62 of Karnataka VAT Act, Your Lordship. That is going simultaneously, Your Lordship. And my appeal is also not being considered, Your Lordship.
What is
And
your liability? What is
Your
the
Lord,
liability?
liability arises around 1.5 crores, Your Lordship, inclusive of all 3 assessment years, Your Lordship. There are prima facie errors in the calculation, Your Lordship, because a bank account of a different party has been assessed and they have put it on me, Your Lordship. It does not belong to me at all, Your Lordship. So there is prima facie errors, Your Lordship.
Let us see,
So-
we'll ask the government to find out. Just find out what has happened to the appeal.
Yes, next week, ma'am. Next Wednesday, ma'am.
Yes. HCGP accepts notice for the respondent. This is the matter in the same stage on Wednesday. Yes.
11.
Very well.
Office objections to be complied with.
Your
in
Lordship,
the
with
interim.
respect to office objections, Your Lordship, I have cured everything else, Your Lordship. Only the prayer part is there, Your Lordship, which I limit my prayer upon hearing, Your Lordship. I don't want to press on all the prayers, Your Lordship. I will limit myself to.
Let us, yes.
Very grateful, Your Lordship.
Pass our matter, serial number 19, VB Shivakumar.
Sorry, my lord, I was not there. It's a short issue that was raised.
Yes.
Property of the petitioners was acquired and compensation was to be paid. But the land is now taken over. What the authority do at page 20, they refer it to the civil court on the ground that there is a dispute. Page 24.
Just a minute. Street in that. They refer it?
They had referred it to the civil court, saying that there is a dispute with regard to the compensation paid. I turn to page 24, para 10. It's further submitted that compensation amount has not been disbursed to the respondent for the following reasons. Claimants, reason for non-disbursement of compensation. Significant, claimants have failed to prove ownership and produce sufficient ownership records over the suit property. But this was one thing that was pending. And thereafter, we made an application that there is no dispute with regard to ownership. Matter is pending. Page 29, we have asked for enhancement of compensation. The KIDB authorities are holding this particular claim petition without it being referred to the civil court for enhancement of compensation. Therefore, submission is on a mandamus to consider our request insofar as disbursement of compensation and also for referring the proceedings.
AG accepts. Now this is KIDB, is it?
KIDB, I'll take it to Mr. Krishna or somebody. But a day's time it could be
No,
accepted.
correct. You may have to amend your cost title.
The next page is that special land acquisition officer.
Correct. You should insert KIDB.
I'll do KIDB, I'll insert it. Sorry, my lord.
Petitioner permitted to amend description of the second respondent. Yaru KIDB. Land Council. Vasanta is directed to accept notice of second respondent. List the matter in the preliminary hearing list, short date. Yes.
I'll do it right.
Yes.
Whose matter? Saraswati M. Saraswati M.
Hearing for petition, 230 matter. Two thirty matter. 230 matter.
Yes, KIDB, who you have?
Chandrasekhar, he was appearing. Chandrasekhar, KV Chandrasekhar, Mr. KV Chandrasekhar.
I'll pass over, you bring him, I'll take it.
Please, ma'am.
Pass over.
Serial number 2, Harish V. Mood matter,
32.
Harish.
Harish versus.
Yes.
My lord's challenges to a notice that's been issued under section 74. There's no specific reason as to why the section has been invoked, my lords. In fact, the assistant commissioner finds records a finding that contravenes and says that the petitioner has diligently discharged the liability. My lords, the tax amount, there's no dispute. We have already paid the tax amount. The interest also, there's no dispute. Now, what remains, my lords, is whether 100% penalty is leviable or not. That's the limited point. The record is, the order does not speak any or infer anything that expresses any willful suppression or intent to evade. If my lords may have me at page 40 of the order, my lords.
My lord, order in original has been passed at 5/2/2025 at Annexure A. My lord, subsequent to order in original, there is no appeal filed in respect of this order in original, my lord. The petitioner contends that he has paid the tax liability, however, is aggrieved with the penalty because the section invoked is section 74, my lord. My lord, it is always open for the assessee to file an appeal and seek an order to be set aside. Now, my lord, after having suffered the order and having paid the penalty, now the attachment, why it's in the due course that the attachment has happened, my lord. That is, once the order in original is passed, he should file appeal within the statutory limit. Once the department has found out there is no appeal, in the due course, it has proceeded to attach the bank account for the balance amount of penalty, my lord.
Lords, interimly, after the order was passed and tax liability was discharged, my lords, bona fide, the petitioner has filed SPL under 128 to avail benefit of amnesty scheme. But that's not available since the order is under section 74, my lords. So that's the reason for delay, my lords. That contentions has been taken.
An amnesty scheme is only available if the proceedings are initiated under section 73, my lord. The moment section 74, that is fraudulent activity or suppression, then the amnesty scheme is not applicable to the particular
You have to invoke the statutory remedy.
My
How
lords,
can
we are
interpret-
already barred by limitation there, my lords.
No, that we'll see. If you are ready to go there, we may make some observation. We'll make some observation. You take it up in appeal. On the merits of the matter, you fight it out, that the penalty is disproportionate, whatever it is, you can raise.
No, my lords, but from the show cause notice itself, the assistant commissioner ought to have made observations that expressly note that this is where I have intentionally concealed any facts, suppressed any facts.
Now it's not open at this stage to enter into that. You have a statutory remedy, you go there, you make out a case. And then if the authority make out a case in appeal regarding penalty, how we can interfere here? Now insofar the delay, we can consider and make some observation to enable your appeal being taken.
That will suffice the purpose at this stage, my lords. It should be.
So it should have been filed 107, is it?
107, my lord.
Within
3 months.
3 months. The petitioner has sought for issuance of writ of certiorari, set aside the order in original at annexure A, comma, petitioner also sought to set aside show cause notice annexure B, and has sought for further relief of issuance of writ of mandamus to adjudicate proceedings under section 73 instead of section 74 of the CGST Act. Petitioner admittedly had suffered an order of adjudication at annexure A. The said order also imposes penalty. It is further made out from the facts that the petitioners paid the tax and the interest. And
Interest is not paid, my lord. I'm so sorry. Interest is not paid. Yes, tax has been paid.
Has paid
Yes.
the tax component in terms of the order impugned, which is the order of adjudication. Full stop. It is the case of the petitioner that petitioner was of the bona fide impression that benefit under section 128 could have been claimed, and accordingly did not take steps to challenge the order insofar as interest and penalties concerned. Petitioner submits at this point of time, since the appeal, even if filed, would be time barred. Petitioner has no other remedy except to knock the doors of this court. Learn. Counsel Shri Arvind Chavan submits that an order which ought to have been challenged in appeal cannot be reopened by way of a writ petition, and if a writ is to be entertained, grounds for bypassing statutory remedy have not been made out in the present circumstance. It is noticed that the explanation of the petitioner for not having availed of the statutory appellate remedy is that the petitioner was under the bona fide belief that benefit under 128 could have been claimed. It's an admitted position that the benefit under 128 is admissible only with respect to proceedings under section 73, and petitioner may not be eligible for such benefit. Next, taking note of the assertion of the petitioner regarding his impression of benefit under 128, it would be appropriate to remit the, to relegate the petitioner to challenge the order in original before the appellate authority and raise all contentions. The bona fide belief of the petitioner regarding availability of 128 could, in the peculiar circumstance of the case, be taken note of so as to direct the appellate authority to take up the appeal while waiving the delay. If the petitioner were to file an appeal against the order in original within
Milords, as 4 weeks, Milords.
For whenever,
within
4 weeks, he said.
4 weeks would
4 weeks
sufficient.
from receipt of certified copy of the order, same appeal to be taken on record with the appellate authority without raising any objection on delay. All contentions are kept open.
Milords, if my
Learned Counsel Arvind Chavan accepts notice for the respondents. No more relief.
No.
Milords, my attachments, if could be conveyed.
How we could
That attachment is made on the penalty amount which, because he had not filed any appeal.
now there suppose he files an appeal, then 20%.
And deposits 10%.
10%. You deposit now, we'll pass.
Please, my lord.
I'll pass an order.
If he's willing
So
to
be it,
deposit.
Milords. But that should give me access to my accounts.
Correct.
Milords.
So you undertake, we'll observe that and we'll direct them to lift the freezing.
Fair enough. We admit to that. Milords. I concede to that.
In light of the submission that accounts of the petitioner have frozen, the petitioner submits that he would pay 10% of the disputed tax.
Disputed penalty amount.
Not
Because
penalty
tax
amount,
already has been deposited.
Correct. 10% of
the disputed tax.
Whatever the pre-deposit requisite is, statutory requisite, we'll discharge, Milords.
Would pay the amount equivalent to pre-deposit if we were to file an appeal. In light of said submission, upon such amount being remitted to the respondent, the instruction for freezing would be withdrawn immediately thereafter.
After the deposit.
Yes.
And Milords, while we get the access and make the pre-deposit, they want the DD from the bank, Milords. The letter's already been issued. No precipitation to that effect, if the court may observe.
No further.
Bank is not.
No, the respondent not to take any further.
Bank is not made a party here.
No, it's
respondent not to take further precipitative steps to enforce recovery in light of undertaking.
It is now already attachment garnishing notice is issued to the bank. Correct. Now my learned friend has not made bank as a party, so bank will encash it, or whatever is the amount is there, they will encash and deposit to the GST treasury. No, he should have made bank as a party for that.
Now you pay to them and then you seek for an adjustment.
Please.
My lords, another contention, my lords. If the penalty or interest amount is taken or given by the bank to the department now, then I will be denuded from the benefit again, because the scheme says that once interest or penalty has been paid, I cannot reclaim it back. So I am before my lords on this limited point.
Okay, so what is the relief you want now? Further relief?
My lords, let them not take money from the bank account to the treasury, my lords. That's the, because it's only penalty, my lords.
Correct. Now this 10% pre-deposit you calculate and you pay to the bank, there ends the matter. Let us see. If there's anything else, you ask the department to adjust it. It's made clear that in the event, for any reason, the bank recovers the entirety of the penalty which the petitioner herein has undertaken to challenge by way of appeal. Upon appeal being filed, petitioner is entitled for refund of amount apart from the free deposit amount.
And let that not prejudice me to avail benefit of 128 milliards. If
That
they've taken the.
I've left- That I've left it, that you see. You've got enough concessions. Yes, next.
So 231, Abhinay Oiti, Vasudevan.
Lord, in this, the compensation has already been received. Petitioner already
Compensation
received
is
the
paid, my lords.
Paid.
That has been paid. I will place a copy of the RTGS form.
The petitioner had filed the writ petition seeking for issuance of writ of mandamus to the third respondent to consider representation at annexure C. It was the contention of the petitioner that compensation for
Acquisition of the petitioner's land.
acquisition was not paid. Counsel for the respondent who entry filed a memo which reads as hereunder. In light of the same, the grievance of the petitioner stands redressed and does not call for any further adjudication. And in the recording, the taking note of the contents of the memo, petition is disposed of. So the council also should get a good fee now.
Petitioners.
Huh?
Hopefully, my lords.
Huh? Yes.
32, Shiva Vishwan.
I appear for petitioner. While granting the interim order, my lord, there is a date of the order, that impugned order, my lord. Date mistaken has been arranged, my lord. In the date of order, my lord, 33/24, my lord. I have sought for our impugned orders, my lord, annexure D and E, my lord, 19/12/23 and 24/11/23, my lord. The date of orders, my lord. I have sought for interim order. You will have to kindly see the prayer, my lord, interim order, my lord. That the date is mistakenly, my lord, wrongly mentioned, my lord. That is 33/24, my lord. Actually, that should be 19/12/23 and 24/11/23. Annexure D and E, my lord. And the interim order, my lord, in the writ petition, my lord, that it is a constitution violated of section 16(2)(c), my lord.
24/11/23 and 24/11/23.
Yes, sir. 19/12/23 and 24/11/23, my lord. Annexure D and E, my lord. Interim prayer, not ink page number 18, but in there. And they, with regard to the payment, 10% of the demand amount, 10% of the tax amount, not demand amount. That is usual in the state government.
Just have a look at this. But how I can correct it, you know? Idu kodu.
Yes.
But how I can correct it now? It has to go before the same court.
In the connected matter, the tax amount, 10%.
Correct. I can't rectify that order. It has to go before the same bench according to protocol.
Same bench
procedure.
ಮುಂದೆ ಹೋಗ್ಬೇಕು, my lord.
Same bench.
Yes, my lord.
Well, I am told in office, my lord.
I have no problem. You have no problem. Somebody else may have a problem.
If it is posted before the
will direct it to be
same
posted.
bench, my lord, that I have no problem.
In light of you filed a memo, is it?
Yes, I have filed.
Memo or
Not
IA
memo.
1 of 26 has been
I have
filed seeking
filed an IA, my lord.
modification of the order dated 15/9/2025. The said IA to be posted forthwith before the same bench, after which matter may revert to the regular bench. Yes.
Next Monday, my lord, that next week. Date,
Martar.
next week, my lord, that one.
33, Shivkumar.
Yes, sir.
Yes.
My lord, in this case, I was transporting goods from Haryana to the city market in Bangalore. I'm the transporter with a valid invoice and the e-way bill. Invoice may please be seen at annexure D, page 84, and e-way bill at 85.
First time it's coming.
ಇಲ್ಲ ಇಲ್ಲ ಆಲ್ರೆಡಿ ಬಂದಿದೆ. ಲಾಸ್ಟ್ ಟೈಮ್ I only, your lordship, I have taken time because destination of places I want to identify. It's within 50 kilometers. This honorable court may be allowed.
If it is within 50 kilometers from the place of the transporter, no updation of e-way bill is required. As per proviso to rule 138.5.
Rule
138.5. The allegation is that I have not updated the e-way bill from the railway station
Rule 130.
to the city market.
So you just repeat the facts now.
Sir, my lord, I was I'm the transporter. I was transporting goods from Sonepete, Haryana to the ultimate buyer who is at Gundapat State City Market. The validity of the e-way bill was there till the railway station Bangalore. The goods came through rail. Then I unloaded the goods, and I was trying to update the e-way bill. Meanwhile, I was intercepted in the railway station, and they asked me for the e-way bill, updation of the e-way bill. Updation of the e-way bill was done at 11:22. It was intercepted at 11:18, but at 11:22 I uploaded. I went after unloading the goods from the railway wagon. I went out to a cyber cafe to update the e-way bill. Meanwhile, I was intercepted. In fact, for transportation of goods from railway station to the ultimate buyer place, which is less than 50 kilometers, no updation is required as per the proviso to rule 138.5.
Just read the provision.
Yes, my lord.
Have you extracted it?
Yes, my lord.
So we can set aside the order.
Yes, because it is within the 50 kilometers. What happened in destination place, my lord, they have mentioned market. But the e-way bill will be end in the railway station.
Correct, but it's within 50 kilometers.
Yes, ma'am.
Your officials also know the law.
I will read out the proviso, my lord.
I've seen that. So we have to set aside which order?
Annexure A. So annexure, sorry.
Annexure?
Annexure B.
Annexure B.
B, my lord. B. That is the order of demand of tax and penalty at page number 71.
Nodi.
I filed an appeal also before the first appellate authority. First appellate authority dismissed my appeal.
On what ground?
On what ground? Of that not updated. The e-way bill was not updated.
What is this position of law? Every day in or day out they are doing it, isn't it? They must know. So we have to set aside
Annexure B, my lord.
Annexure B.
A and B. A is appellate authority order. B is the adjudicating authority order. Annexure B at 71, page number 71.
Where is the original demand? That is B, is it?
B. Original demand.
The petitioner has called in question the correctness of the order at annexure A, which is the order in appeal. The appellate authority has rejected the appeal of the petitioner filed challenging the demand at annexure B. The demand at annexure B relates to lack of e-way bill.
Updation of e-way bill.
Relates to absence of updation of e-way bill to the point of destination. In the case of the petitioner, that the petitioner was engaged in the transportation of goods. It is submitted that a supplier from Sonipat, Haryana had consigned goods in the name of Messrs. Atul Enterprises situated at City Market. Full stop. Further submitted that the goods reached the Bangalore railway station and on 13/11/24. Full stop. The petitioner went to the railway station and had the goods unloaded to a cargo vehicle and had parked the vehicle, which unloading was completed at about 10 a.m. Full stop. Further submitted that the respondent number 2 intercepted the vehicle at 11:18 a.m. when the vehicle was stationary and parked in the premises of the railway station. In the interregnum, at about 11:22 a.m., the e-way bill was updated. However, the authorities had already initiated proceedings and raised a demand. Appeal filed against such demand also came to be rejected. Next. The only point for consideration as to whether the e-way bill was required to be updated. Rule 138,
Class 5.
Clause 5 of the CGST Rules 2017, along with the proviso, reads as follows. Full stop. It is clear that in terms of the proviso, the updation of e-way bill would not be required where the goods are transported for a distance within 50 kilometers from the place of business of the transporter to the place of business of the consignee. Full stop. In the present case, the fact that the e-way bill was valid till the railway station at Bangalore is not in dispute. Full stop. Accordingly, in light of the same, the demand at Annexure B as well as the order of the appellate authority at Annexure A are set aside.
Yes, ma'am.
Accordingly, petition is disposed of.
Obliged.
Before, Shivkumar.
Yes.
My lord, in this case, my registration under the GST Act was cancelled for the reason that I did not file returns for the 6 months. Then I filed an revocation application. I filed, but revocation application was not considered because of delay in applying for the revocation application. Then I filed an application before the commissioner for condonation of delay. The commissioner condoned the delay and order. I will, kindly see Annexure F at page number 45. Order of approval of application for condonation of delay in filing revocation application of cancellation of registration. I will read out, my lord. This is reference to your application dated 24/2/22 for condonation of delay in filing of revocation application of cancellation of registration. Your application has been examined and the same has been found to be in order. Accordingly, the delay in filing is condoned and the application is forwarded to the jurisdiction authority for further necessary action. This has not been acted upon. This is from the commissioner. This has not been acted upon. Apart from that, I went before the first appellate authority through an appeal. The ground on which the registration was cancelled is not filing return for 6 months. But the appellate authority gives me a different reason in his order, stating that.
Sorry for interference. In this matter, several matters, my lord, for non-filing of returns, this honorable court is already held in favor of the petitioners that directed to file the returns of income along with directed to pay the penalty interest and allowed the writ petition. They may be allowed.
I am prepared to file all the returns if there are any taxes to be paid.
Judgment could be
taxes and.
But where is the order of Cancellation.
Order of cancellation is at
Page number, Annexure B, page number 38. my
Annexure B
lord.
38.
Now, what happened to your revocation application?
The revocation application was considered by the, no, it was cancelled. Revocation, it was not considered.
No order was passed.
No order was passed. Even after the commissioner approving my condonation of delay,
The petitioner has it's called in question the validity of the order by the appellate authority at Annexure A. In terms of the order at Annexure A, appeal filed by the appellant, by the petitioner, appeal filed by the petitioner challenging the order of cancellation of registration came to be rejected. Why was appeal rejected?
appeal was rejected on 30th April 2022 at Annexure A, page number 32.
On what ground it was rejected?
Altogether a different ground. There was an intelligence report from Hyderabad, and based on that intelligence reports, you're not eligible for cancellation, I mean revocation.
The appellate authority
Altogether different ground, my lord.
had directed verification of the appellant's input tax claim and observed that if the input tax claim utilized by reason of fraud and output tax was not paid, or tax invoices were issued without actual supply, then such aspect was to be investigated. The next counsel for the petitioner submits that the order of cancellation was passed while making the observation
Not filed returns.
that with inverted comma not filed returns. The petitioner filed an application for revocation, though belatedly. The delay in filing application for revocation was, however, condoned, and matter was directed to be decided by the proper officer, by the commissioner, in terms of Annexure F, dated 29/12/22. However, it is submitted that no order was passed on revocation taking note of the grounds urged by the petitioner. The counsel for the petitioner submits that though appeal was filed against the cancellation, reasons assigned in the appeal order have nothing to do with the ground made out for cancellation and relate to other aspects, while it was not open for the appellate authority to enter into such contentions. Next. Now, HCGP submits that if the petitioner were to pay the tax for the file the returns for the relevant years and pay tax dues along with interest and penalty, appropriate orders may be passed. In light of the
And directed to file his return and pay the tax, penalty and interest up to date.
in light of such stand of the HCGP, petition is disposed of as follows. The order of cancellation of registration would stand set aside subject to the following. 1. The petitioner to file returns for the relevant years and pay tax dues along with interest and penalty within 4 weeks from date of receipt of certified copy of the order. Next, the petitioner fails to file returns, pay tax dues and interest as directed above, the indulgence extended by cancelling the order of cancellation would stand revoked. Accordingly, petition is disposed of.
Pleasure.
CGP accepts notice for the response.
35, Ravi Kumar M. Murugeshri.
IA number 1 and 2 filed for not to demolition the existing structure and not to remove the cut and remove the standing trees in the acquired land. And the subject matter is bricks industry running by the petitioner prior to the acquisition. Prior to the acquisition. 2011, Malad has filed the writ petition and filed the objections to the BDA for the acquisition since he was running the bricks industry. 2011 order, Malad, Annexure C, page number 65.
Name it one submission, but this very same petitioner has filed the OS number 61 of 2026 on the file of the City Civil Judge, Bangalore Rural District, and seeking for an injunction against the very same properties. May I pass on this?
That is the internal dispute between the GPA holder and the petitioners, Malad, not against the BDA.
But,
It is the issue before this.
Not against anybody.
That is admitted
the
fact.
Commissioner and the Bangalore, the land acquisition officer.
Not to disperse the compensation, that is a relief claim in this suit.
May kindly see this. Lord, may kindly see page 8. Lord, first page, Lord, the very same petitioners represented by the very same, the power of attorney holder, and Lord has filed a suit. 8, Lord, page 8, Lord. Lord, may kindly see to restrain the defendants, their agents, their legal heirs, henchmen, or any other person claiming under them from interfering with the peaceful possession, enjoyment of the suit scheduled properties by the plaintiff by decree of permanent injunction, so and so. The scheduled properties are not the 146/2, item number 2 is 156/1, item number 3 is 167/1. Not the very same scheduled properties, what has been sought now. Lord, in fact, Lord, we have taken up a contention in our, sorry, Lord, sorry to interrupt, in the present writ petition, that the power of attorney on the basis of which the present petition is filed, and Lord, the petitioner, the one Mr. Sunil Kumar, who is representing the petitioner, Lord, other petitioners, Lord, are fighting amongst themselves, saying that there is no such right which has been given to them. And Lord, the suit which is filed, I placed that on record. And Lord, in which injunction was not granted, a writ petition was filed seeking for certain reliefs against amongst themselves. Lord, and I have taken up a contention that the power of attorney holder who has come before this court himself has given a representation to the BDA asking for a compensation from the BDA. And Lord, at this point of a time, Lord, when they come and ask for a compensation there and coming and asking for an injunction from us not to interfere, not be permissible is my responsibility. I'll be able to point out.
Yes, given a representation.
Yes, they have sought for a compensation from us. Lord, may kindly take my statement of objection, Lord.
Writ petition 17 March 25 order, Malad.
Annexure R2, Lord.
Okay, but no.
Annexure A.
No, in the suit,
yes,
you have sought for a larger remedy.
Larger remedy.
The other remedy must be in the suit.
The
suit is filed making the BDA as a party.
Yes.
How we can entertain a writ? Now, if you have sought for a larger remedy of not to interfere, then the smaller remedy not to cut must be there. How the writ is maintained?
Annexure A, Malad, page number 18.
R2 may be seen, Lord.
Annexure A, page number 18 order. This honorable court passed the order, Malad.
No, no, that may be so. How is the writ maintainable?
My lord, kindly see, my lord, Annexure A, page number 18, the operative portion, 27, my lord. Page, my lord, Annexure A, page number 18.
No, why did you file the suit now?
My lord, suit is internal dispute between
No,
the.
no, it's filed against the BDA.
My lord, BDA, his land was acquired. In case if they release the compensations to
No,
the
no, that's
GP.
not, you have not seen the prayer in the suit. Could it? You have a look at it. I'll have it on Monday.
And my lord,
No, no, it's not maintainable. Look at the prayer in the suit. How can we maintain a?
My lord, page number the 27, kindly see the
Yes,
order
sir.
of this honorable court.
Unless you explain how the suit, I'll have it on Monday. You have a look at it. Suit covers the whole relief, what you have asked. You have to withdraw it and go there. I'll have it on Monday, however. Release the matter on Monday. The counsel for the BDA files a memo and encloses a copy of the plaint and submits the larger relief having been sought for before the civil court. The lesser relief that is sought by way of a order of restraint not to cut the trees cannot be entertained in the present writ and ought to be adjudicated only before the civil court. The say of the petitioner. Relist on Monday. Yes.
36, Saraswati.
The BDA has passed a notification.
That's for respondent video.
The notification is 1986, my lord. I am the subsequent purchaser, my lord. Other matters have been pending, my lord, that is been posted on 16th of this month, my lord. It may be tagged along with that.
Council accepts notice for the respondent. Relist along with WP number.
I have given the, my lord, one more submission, my lord. In other matters, there is a status quo, my lord. Same may be granted.
We'll verify, my lords.
Huh?
We'll verify that, my lords.
No.
They're saying there's order of status quo.
The lordship only has granted in the earlier.
You have a copy you can give.
I will give permission.
Kindly pass over. We'll verify.
Pass over.
Please.
Yes, next.
37, Saraswati.
So, Lordship, in the first matter, my lord, the petitioner, my lord, had claimed, my lord, TRAN credit, my lord, TRAN 1, my lord, had sought for credit, my lord. The same was denied, my lord, and because I could not produce the sufficient documents in invoices and all. Therefore, I approached this honorable court, my lord. And this honorable court, my lord, by the order dated, my lord, remanded the matter to back to the assessing authority to enable me to produce the documents, my lord. After the remand, my lord, so, Lordship, this honorable court order is dated, my lord, 4/9/2024. So, Lordship, after the remand, my lord, at page number 22. Your Lordship have filed this letter, not 27/9/2024, have produced the invoice-wise, party-wise, and duly claimed statement, sample invoices, and a copy of this honorable court judgment copy. And after that, Lord, on 27/12/2024, at page number 39, my lord. Page number 29, Lord. I'm sorry, Lord. Page number 29 by email dated 27th December 2024. I have attached all the required documents, DRC 1A on GST TRAN PDF and Bauer Lifestyle TRAN 1 order copy of Karnataka High Court, and also the further documents TRAN 1 acknowledgement copy of the GST TRAN 1 notice document submitted PDF. And again on at page number 28 on 29 January 2025, attach further documents, the last 3 lines from the attachments, not in the first 3 lines, documents submitted or empty exercise claim, the 36, 2017, and Excel sheet Puma exercise workings, my lord. And further, my lord, after that, I have produced one, I have sent one more email and 29/1/2025 at page number, that is at annexure E, my lord, page number 27. Have enclosed this the documents showing the closing stock held by me as on 31/7/2017. This empty exercise claim discloses the invoices as well as the breakup and closing stock. All these documents were produced, but in the impugned order, the learned assessing officer has said that I have not produced any material relating to closing stock. All these documents were before the authority at page number 15, paragraph number 14. In the middle of the page, your lordship may kindly see detailed stock register is not produced. All these materials were produced in the email.
Correct, but this is a disputed question that has to be taken up in appeal.
Your lordship may kindly see, I have produced the material that has not been looked into. There are about 13,000 invoice copies which discloses the purchases made by me that has not been verified. He simply said I have not produced. Just let him verify the documents. What are the I have produced? He says that closing stock, the details are not been produced. It is all there in the email which I have sent. It is about 13,000 invoices. He just ignored all this, my lord, and says that I have not produced.
We could remand, provided, let him appear before the officer.
Please.
And point out from the documents that he has sent. And if he satisfies and you have instructions, then we'll remand it.
Please. Please.
To appear before them and satisfy.
Please.
Then we'll remand it.
Please, my lord.
First time, is it?
Yes, yes, second time. And last time, Arvind Chavan had not taken.
Petitioner.
My lord, I am appearing in the first matter. Second matter, only Krishnan is appearing.
The petitioner in both the matters contains both similar orders.
Both similar. One is strand 1, second is strand 2.
Contents that the authority has not taken note of the documents produced by the petitioner referred to at annexure
E, my lord.
Annexure E, and is merely asserted that the value of inputs are not matching with TRAN credit availed.
Yes, my lord.
It's full stop. Further submitted that the documents referred to in the emails at annexure E are sufficient to record a finding regarding the mismatch between value of inputs and TRAN credit availed, and petitioner would demonstrate the same if the matter is remitted to the assessing officer.
Please, my lord.
Full stop. To demonstrate bona fides, petitioner to appear before the
Respondent. The first respondent.
first respondent on date and satisfy the authority regarding availability of material.
Yes, my
To
Because the authority has said that details of stock register is not produced.
availability of material.
Yes, my
Full stop. The counsel for the revenue to obtain instructions as to whether the petitioner has produced before the authorities relevant material.
Your Worship.
Relist the matter in the preliminary hearing list on
After 2 weeks, my lord.
After 2 weeks.
Yes, my lord. Your lordship, liberty may be reserved to produce even the additional documents if any.
The petitioner is at liberty to furnish material and records apart from those referred to at annexure E, which would enable the petitioner to demonstrate matching of input value and TRAN 1 credit availed.
Please, my lord. Yes. Date of appearance, my lord.
Date of 25th of February.
Please, my lord.
25th. This one is it? 18th date. Next date of hearing.
Next date of hearing here is
4th of March.
4th
of March. Okay.
Bail ante.
38, Kariyappa NA, Prasanna Kumar P.
First petition, my lord, is for on-city bail, my lord. Not, in this, my lord, already there is an order of bail.
My lord, 38.1, my lord, I appear to be respondent. The matter was directed to be listed on 19.2. It may be detailed and heard separately.
32 has 38 point?
8.1, my lord.
Ah.
The matter was directed to be listed on 19.2, my lord. I meant to file my statement of objection.
So that we'll see. We are only in the first matter.
Not my submissions will be same, not for both of them.
Ah.
Let me learn and friend cooperate, not since not there is an order. You should cooperate, not you can't take an order and then not. I have served not copy long back. But time has already been taken.
Here,
No, which is this 38 is first time it's coming.
38, my lord, it was listed before the coordinate bench, my lord, regular court of bail. It was listed, my lord, it is pending since more than 1 month. Now it has been got tagged, my lord, with the 38.1 because the matter arising out of same crime.
My request is, will not let both my learned friends will not make their submission. Otherwise, I will have to trouble your lordships again and again with the same papers. Let my learned
Here,
friend
but
also
the
cooperate.
impugned order, my lord, is not arising out of special court order, it is.
Which one?
38, my lord.
It has nothing to do with special court.
No.
No, not the order was.
RC number would be same,
RC
but
would
not
be the
when my
same.
learned friend filed the petition in the trial court. That was assigned to not a regular CBI court. And now not the other one not was assigned to.
No, correct. What I want to know.
Please.
The second one is before this roast.
Please.
The first one.
Please.
Is co-accused or nothing to do with.
No, it is co-accused.
Co-accused.
And what happened was not in the trial court, since he is a private party, his petition was assigned to not the CBI special court. Not
correct, but suppose it should have gone to the same.
It should have definitely gone, but prayer was made, and since it is what is same, they have addressed their arguments. Since it was assigning, was duty of the registry, though it was brought to the notice of the court. However, we have made our efforts.
No, but that should not be done.
Of course not. Of course. I understand. Because otherwise, now.
No, it has other implications.
Sir, it has happened, my lord.
In this case itself.
The next matter, my lord, on-city bail is granted for the co-accused. Say the other court, my lord, of Sessions Court, rejected for this accused. He is a private party. He has done nothing. Bail has been refused for him. One court, bail has been granted for another accused by the other court. This inconsistent finding, my lord, has resulted leading to these two petitions.
But somebody has taken a chance. Yes.
But my only humble request is, let my senior friend also not argue. Let my learned friend not for the other co-petitioner also argue. No, my case is respondent. So I will not.
No, correct. But I'm just asking. Before going into the facts.
Please.
If it is the case that the co-accused has been granted bail, anticipatory bail, or
which we have sought, not cancellation.
Correct.
Please.
But then this other co-accused on parity, unless there is something different from him, is entitled. And then
I'm arguing the converse. Since his petition is rejected, this petition of the other also should have been rejected. Therefore, he is not entitled for anticipatory bail. I'll bring to your lordship kind notice what is the material which we have collected so far. It's a court-monitored investigation, and why we require custodial interrogation. I'll bring to your lordship kind notice precisely to the point. I'll not beat around the bush.
No, correct. But would it not be appropriate, subject to what both of you say, that this man be given some protection, and then both be
heard together?
Therefore, I am ready. I am ready now.
No, I'm saying only as an interim measure. We will not grant regular interim measure, and this one
we have very serious opposition, not even for consideration. Therefore, I am ready as on now with case diary, case papers, everything. Even the documents I put flags and everything. I'll be able to assist this honorable court. I'll go on with the matter. It is not that I am seeking time. Definitely not.
What is the date fixed in the other matter?
19 to 16.
16. All this shows it's 16. But anyway, my lord, my learned friend
But,
has argued
here-
the matter in the trial court. But he cannot, my lord, my only request is let him argue and cooperate. If he's really entitled to, your lordship will consider. If not, my lord, I think I will, both of us will get an order. That's all. Instead of dragging it, my only request is, if not today, let him argue tomorrow. He has all the material with him.
May I make one submission, Your Lordship. This Your Lordship may kindly see, my lord, this petitioner, my lord, was already arrested in respect of same subject matter of offence.
Already
He
arrested.
was arrested, he was granted bail by this court, my lord, in crime number 118, my lord, which was investigated by SITT. My lord, then ED arrested. In that also he obtained bail. My lord, this is something unfortunate that the investigation was extended to some other area where no offence is committed. They sought the permission of coordinate bench, my lord. Coordinate bench allowed to investigate even that area of suspicion where investigation required. Investigation was allowed. We filed an application for impleading in that and also for recalling that order. During pendency of that impleading application, interim measure, my lord, that not to take coercive step was there till the disposal of the application to recall the order. Once the application for recall the order and impleading application were dismissed, that coercive order, my lord, which was given to this petitioner came to an end. Immediately we approached for unseated bail. The Sessions Court, my lord, rejected the petition. Therefore, we have approached here. Till the disposal, my lord, interim measure, my lord, not to take coercive step, my lord, same order can be, or in interim unseated bail may be granted, my lord. Thereafter, my lord, it may be disposed of either tomorrow or any day. We are ready. Even now, I am ready to argue. No offence has taken place. He has already suffered custody. He has cooperated for investigation also. They have issued notice. He has appeared. In future also, he will go. He is not hesitating to explain what is the transaction. But one fact it is that no offence is taken place in respect of the amount which has been transferred to the account of this petitioner, which has been accepted by elected representative court and granted unseated bail to next matter. That court has held that no offence has taken place. That is what our stand is. The contractor, my lord, who has taken contract, your lordship, from the Department of Scheduled Tribes Welfare Department, from his account, my lord, about 1.02 crore, my lord, has been credited to the account of this petitioner. My lord, therefore, the CBI, they raised the suspicion that we want to investigate on this. Accused appeared. This petitioner appeared before them, told that they have given me as a loan. I have credited, I have shown in my income tax report, income tax returns, that it is a loan amount that I have received it, for which I have paid already the income tax, and I am showing it, it is a legal amount. No FIR was lodged in respect of any irregularity being committed by that contractor who has credited this amount. Anyhow, this point was considered by the coordinate bench, but it is allowed for investigation. Let the investigation go on, but protection may not is required. He has been already suffered twice at the hands of local police, at the hands of ED, and my lord, CBI, my lord, their role, my lord, is, your lordship, very important is CBI sought for investigation. This FIR is registered only against bank officials under the Banking Regulation Act. He is a private person. Against them, my lord, they have taken, my lord, whatever the steps it is, investigation is about to complete. My lord, they raise a doubt about the petitioner receiving, my lord, 1.2 crore from the contractor. They want to investigate, they sought for permission. Permission is granted. We sought for cancellation, that has been rejected.
So, otherwise, we can do one thing.
Please.
Unless you feel that both are differently placed.
Please.
If you feel that it's intertwined, and what would apply to one would also in equal measure apply to the other, then we can start together, unless they have to be decided separately.
Not, I am ready with whatever which will read senior friend is making submissions. I'm ready, not with all the papers, not even IO papers is also here. I'm ready to assist this honorable court. My only request was, not, it will be a burden for this honorable court to hear it again and again. That's all, nothing else. Not, I am ready, even now. I'll bring to your lordship kind notes within
Okay,
maybe.
so you say which date, and then we'll both of you.
I'm ready even now. Not, they will have to not because one person is seeking interim bail, other person is not ready to argue. I'm ready to argue.
At short
will
date,
have-
I'll file my statement of objections.
Huh?
Short date. I'll file my statement of objections.
Which matter? No.
38.1, my lords.
In that you appear for?
Respondent.
A respondent accused, not where, who has been granted the
Granted
benefit of
unseated
not
bail.
anticipatory.
This is limited some protection as an interim.
Not, can I not bring to your lordship just few facts, man. Not, can I trouble your lordship not with the petition that we have filed, man, the other one? Because I have produced all the documents, not in that. Just 2 minutes, not just 2.
858.
858.
Good.
But may I draw your lordship's kind attention in this, not page 128. Now, this is a writ petition. No, my lord will find the prayer of that writ petition not in page 129. Para 2. Petitioners, sitting members of the Legislative Assembly, are at the doors of this court seeking following prayers. Direct the respondent, that is not CBI, to investigate the first information report dated so and so in RC number so and so produced in annexure C at the earliest, and consequently file appropriate final report in the jurisdictional court in the interest of justice and equity. Direct learned so and so that the consequential relief. Not this writ petition, not the order was passed by this honorable court. This order not is dated 1/7/2025. Not before this also, this honorable court had directed not CBI to report back not with the status report of the investigation, since not a prayer was made that there is delay in investigation on the part of CBI. Not we kept on submitting not the periodical status reports before this honorable court. This writ petition on this case has been treated as not court monitored investigation by the coordinate bench, which is not kept pending as on today. Not during not the submission of status reports, not
Why is it treated as court monitored?
not since not we kept on not the at the initial stages the matter was not with the coordinate bench. Since this honorable court found out not there was a lot of not irregularities that we pointed out to the honorable court in the status report, probably this honorable court felt that it requires to be not that the reason is not known. Then my lord will find not.
We shouldn't do that.
No, I'm not. It is not at our request. It is definitely not at my request.
I think we are already burdened. We don't want to take up unless
I understand.
there is a,
I understand, but that was definitely not at my request, nor at the request of the institution. But my lord will find not page 132 onwards. Not my learned senior friend will not stated that he is already granted bail, already an accused. That is not in that your lordship will find my extract of my report not at para 2. This page 132. Not my report is extracted, the report of the IO. During the investigation, the involvement of public servants, your lordships, public servant in collusion with other accused persons has been prima facie established. It is further established in the investigation that an amount of 89.63 crores was diverted from the accounts of measures Karnataka Marshi Valmiki Scheduled Tribe Development Corporation Limited to a large number of beneficiary accounts. The diverted funds were subsequently laundered into hard cash, bullion, and luxury so and so. Then, my lord,
PMLA.
this is not CBI investigation into not offense under my lord PC Act and IPC offences. Then, my lord, PMLA my lord, that's differently my lord is being taken place. This with reference to Valmiki Corporation. Then your lordship kindly have a look at the next page, my lord, para 6. Para 6 of our report, which is extracted by this honorable court at page 133. Further, the investigation has revealed additional instances. You know, kindly mark additional instances. It's not same case or similar. Additional instances of fund diversion involving other government departments as under number 1. A sum of rupees 95 lakhs was siphoned off from the account of Karnataka German Technical Training Institute maintained at Canara Bank, Bengaluru, and transferred to the account of the accused Nekkanti Nagaraj through intermediary accounts. Who is the petitioner? My lord, senior friend refers to. This has absolutely nothing to do with Valmiki Corporation. Then, my lord, an amount of rupees 2.17 crores belonging to the Scheduled Tribe Welfare Department is again a different department, was diverted from the another account of so and so maintained with Bank of Baroda, Siddhaya Road branch, Bengaluru, and routed to accused in Ekkanti Nagaraj. So two different instances. Not we sought not prayer to this honorable court to permit us to investigate not these instances also to give not a complete report to the concerned court. The order of this honorable court not is at page 134, not last paragraph. In the light of the status report being sought at the hands of this court from time to time, page 134.
Yes. Yes.
In the light of the status report being sought at the hands of this honorable court, it is not that we submitted voluntarily. From time to time, what the CBI has sought is only to further the investigation that is entrusted to it by the bank. Horizons of the investigation is sought to be expanded in view of what is gathered during the investigation, as narrated in the status report. Since the prayer is for completion of the investigation or taking the investigation to its logical conclusion by filing final report with the concerned court, I deem it appropriate to grant the prayer that is sought by the CBI in the status report. Therefore, I direct CID Enforcement Directorate so and so to provide records. Then not this order of this honorable court permitting CBI to conduct investigation with reference to two different instances, two different departments, having nothing to do with not Valmiki Corporation scam was permitted. That was called in question by my learned friend not filing an application not through this very petitioner Ekkanti Nagaraj. That my lord will find the order at page 136. Not they sought impediment, the very same petitioner herein, and may also made a prayer to recall the order. That your lordship will find page 138. My lord, the preamble of page 138. Not para 2 of this preamble. No, these applications are filed seeking permission to implead the applicant as party respondent and to recall, modify, and clarify the order dated 1/7/25 under so and so. But after having heard this matter, this honorable court not felt not that there are no grounds to recall the order and the investigation should go on. Not page 156, the operative portion of the order. Domicile. Open my order.
There is some overlap.
That's what I'm just.
No, overlap between two investigations.
Yes, no, yes, no. There is no overlap. There appears to be not similarity in the mode. Modus operandi is same. Institutions are different. Accounts are different. Departments are different. Persons are same. Not it is like same thief entering into different houses, not stealing the articles.
No, is there an overlap in the investigation?
There is no overlapping in the investigation.
State and central.
No, there is absolutely no overlap. Oh, that was clarified.
Then why was permission required to investigate?
Not since this was not in the within that Valmiki Corporation accounts. Therefore, we sought permission not to make things clear because this.
Correct. What I'm asking.
Please.
That it should be open for the investigation agency to broad base their investigation. Why the court permission is required?
No, it is like this.
During the course of investigation.
Please, of course.
You find out that there is some.
Not why we sought permission.
Some other
I understand. I understand. Not what.
Registered other FIR investigation.
That's exactly. No, we actually this would not lead to another 2 FIRs probably. That's how not the things may not have cropped up now. Therefore, not since we are court monitored investigation, we had to bring everything not to the notice of the honorable court. Not in all fairness, we brought everything to the notice of this honorable court. With the documents we not established. Therefore, this honorable court felt this requires investigation because it's not it's not ultimately public money belonging to different corporations. Now, where this money has gone, the money that I brought to your lord's kind notice that 95 lakhs and 2.17 crores. Not on the other day I made a submission. This my lord money lands up in Mumbai. Not some not two women they take ultimately beneficiaries. My lord they take jewelries. And one of those my lord lady would show her claim herself. Not we do not know the documents my lord which we have collected indicates my lord that she is wife of so and so, the respondent in the other matter. Not why we not generally, as your lordship do not have seen, CBI, we do not generally oppose bail at all. We generally do not arrest anybody at all, 99.99%. Unless the accused are not cooperating, unless not these things crop up in court monitored investigation where apex court is monitoring, this honorable court is monitoring, we are unable to proceed further, may not we come up before this honorable court. Otherwise, may not your lordships have seen, not there are no matters of CBI may not where bail may not is either opposed or done. 99.99% everything may not happens in the trial court.
The only thing is in case we are required to pass an order in the other matter and cancel, then it has to be heard.
That's right.
So it will take some time. Of course, we'll start.
But then, your lordship may segregate the cancellation. Your lordship may take it up on Monday, Tuesday. But I'll go on with the matter. This your lordship may permit me to bring to your lordship a note. What is the material that is now, my lord, staring at him?
Correct. Now, if it involves both on parity, they're similarly placed, or one is worse off, then we have to decide together. There's no point.
That's exactly. That's why I said. But then, not my submission is the material on record as on today that I brought your lordship pay notice now. That will make his case much worse than what was his case before the trial. Not everything has gone to his account. Not only his account, his family account. He claims brother account. Not that exactly during the relevant period when this tender happens.
We are claiming,
but there are direct beneficiaries.
Now unless you are ready, your friend will go into custody. It's up to you. You have to cooperate. No doubt we had given a longer date. Now you have to take a shorter date and finish your pleadings. Then only we can also hear both together.
And I can understand if it is a 439 petition.
Any date next week, my lords. Any date next week, my lords.
Can I just bring just one page?
May I submit one aspect, your lordship. My lord, what is pointed out, my lord, this 95 lakhs. Sorry, yes.
I'm just
95 lakhs and 2.17 crores, your lordship. In respect of this amount, offense should happen. Offense is not happened. This is a legal money. Unless offense is committed in respect of this particular money, investigation cannot be taken up. They cannot investigate at all. There is no FIR, your lordship, for investigation of this. That's what the contention we taken is. We have challenged it. Yes, that order we are going to challenge. It is challenged before the apex court. It is likely to come. But fact, my lord, for the protection is concerned, your lordship, unseated bail is concerned. Prima facie, this honorable court had given a interim protection, my lord, not to take a coercive step. Your lordship may kindly see the order, your lordship. Tendency of that application, my lord, that at page A in our petition, your lordship may kindly see.
Before my learned friend,
page
let me
125.
complete. He will have say. Not may just not pass on.
Argument is not being taken up.
I have not pointed
It's
out.
not
May
taken
just
up
point
for
out.
final hearing.
Why is it? Court will take a decision.
Disposal, my lord, that when one accused is given benefit, the other accused should get. We are claiming definitely a principle of parity.
First lakh, not the monies that have been transferred along before tender antam. There is a small table, 3 or 4 lines table, pencil mark management. That is the money that has been transferred, not to this. Just before the tender, money is transferred to this petitioner and his family members. There is one more pink color flag that I put. That is not the list of money transferred post immediately after not awarding of tender. Not and the petitioner wants to believe, we want just to believe or court to believe that this is just a loan transaction. I can understand not one person taking loan, but family members taking loan, and there are calls. I think I have troubled your lordship with the call record details. What apex court has said time and again. The call details between these accused persons during, before, after the offense is a telltale evidence. He can claim, yes, no, I am the official. I could have called the person who was applied for the tender, but this money will speak much more than that. And he is not an official; he is a private person. And this call record details, he has this CDR, he has links with the minister, links with the MD, links with not these persons who have transferred the money, persons who are beneficiaries of the tender.
All
But
these
there are-
subject
there are
matter
not,
investigated.
There are materials which are steering at him. He cannot claim, no, I did not do anything.
Investigation is completed, charge sheet has been filed.
Not for this.
By
sir.
the SIT, my lord,
Not for
that
this.
this
Not for
cannot
this.
be,
Not for
cannot
this
be
offense.
connected at all.
My only request is not, these are the, I'm just brought to your lordship, just 2 flags. There are 10 more flags like this. My only request is, can the petitioner ask this honorable court to just close its eyes and say, no, other person is granted bail, grant me relief also.
The relief of on-city bail, my lord, apprehending arrest it is. Already a person who has suffered it, my lord, again, why he has to be? My lord, merely because they extend the investigation for some other area. They can't arrest it. Crime is same, your lordship. FIR is same. Subject matter of offense is same. Can they arrest again? This is the question, your lordship. If they want to arrest it, let them register separate FIR it is.
Not all these submissions have been
Let,
negated by the court.
let that writ petition also be tagged to this court, my lord, or to that court. May be decided, my lord, that the writ petition which is filed, my lord, for speedy investigation. There was no such prayer at all that investigation to be extended to this area. That writ petition was only sought for speedy investigation and closure of the report. Nothing more. But this honorable court, my lord, the CBI filed a report.
Has become final.
Status
The
report
Learned
with
Friend is
regard to
repeating his
progress of
submissions.
investigation, not searching other area. If at all, if they have found out, my lord, any other offence had taken place, they are bound to register FIR. They have no authority. It is a state subject.
But now that point, right or wrong,
it has been decided by this honorable court.
Some order appears to have been passed.
My lord, it is passed, my lord. Therefore, we are seeking for on-city bail. We
As
are
on
not
today, that has
challenging
become
that
final.
order, my lord. In view of these developments, no likelihood of arrest, my lord, is they are opposing it. Tomorrow he will
Can I
appear
just-
in corporate investigation,
Just point
whatever
out,
it
my
is.
lord,
my lord, that
one more document. Can I just
is
point
not
out
that he is hiding somewhere. He will, my lord, he has already appeared, my lord. Thrice he has appeared, your lordship. Before this status report, my lord, he has appeared thrice. Those contractors have appeared thrice. They have submitted to them. They have explained. They are forcing him that he should admit that this is an offense. No, FIR itself is not there, my lord, that this point requires a consideration. This 95 lakhs and 2.17 lakhs, my lord, is not the ill-gotten money, your lordship. A contractor pays some money to this man. The contractor is not arrested. He is not an accused. This petitioner is not an accused. We are apprehending arrest, that's all. This honorable court in the coordinate bench, my lord, has held that he is not at all an accused. Kindly see, my lord, the thought. It is mentioned, my lord, that he is no longer, he is not an accused. It is mentioned that page 141, my lord. As per them also, till today, they have not treated him as an accused. In this crime number, my lord, they have not. Page 141, last line, your lordship. Paragraph 7, my lord, it is. If you are not at all an accused, why are you coming before court? This last line, impleading applicant is not an accused. Page 141, inner page 11, your lordship. Last line, your lordship.
Now that stage we have passed.
Yes.
That
This
stage
is
we
the
have passed.
observation. Impleading applicant is not a witness, not an accused. Then why they want to arrest it? No, we apprehend that you misuse your power of arrest. If you are calling him not a witness, not an accused, this is the observation of this court.
No, there's one other way of looking at it. If both have to be decided together, I don't want to split it up. We'll fix a date next week. In the interregnum, let him present himself for investigation, whatever it is, let it go. But don't take him into custody till the next date. We'll start hearing it.
I have brought to your lordship kind notice the material, documentary evidence, which is staring at him.
No, correct. But now can we pass 2 different orders for 2 different?
Not in that case. It is not that I am seeking time. It is not the co-accused who are seeking time.
Now we have.
I am ready to address the argument. Let my learned friend cooperate. I should not, my request is I should not suffer an order for no fault of mine.
Once on-city bail is granted, it cannot be easily cancelled. That is the principle of law. They require some time to answer it.
Now he is saying.
Yes. I take the advantage of that. If my petition had gone to that court, this petitioner would also been granted. The reasoning given, my lord, by that elected representative court equally strengthens my application for recall of order. In spite of coordinate bench order, the elected representative court has clarified when no offense has taken place, when this money is not being an ill-gotten money, now how can they arrest it?
You can have it tomorrow if time permits.
Please.
One of you start.
Please. No, this is not a case of 439. No, he is hiding somewhere. He'll continue to hide for one more day. Nothing is going to happen.
May I request next week?
No, I'm so sorry. I'm not.
Let them start. That's all. Let them start. I'll give you an opportunity. Let them start. I'll give you an opportunity.
My lord, day to day, you will ask me kindly, only that, my lord, not to take coercive step. He should remain, my lord, free. It is liberty.
We have
cannot
very
be
serious
threatened like
opposition on that, not prayer.
That may be so, but we can't have two accused being treated differently for whatever reason. Firstly, I'd express my serious displeasure at this method of two matters being before two courts. Whatever.
But we brought this. We brought this.
No, forget it.
Of course not.
Whoever it is,
Please,
that cannot be encouraged, and that should not be done. And when the court is made aware, whichever court that is, when the court is made aware that the jurisdictional court is something else, what is this? Why should this court have done it? Now, this is a typical case where two accused, for whatever reason, have got different, which should be avoided.
That's the reason Apex Court has been time and again not saying that wherever there's at least one crime number, it must be heard together.
No, correct. So I'll have it tomorrow. You start, but you will have to adjust. I don't know what matters I have.
Please, I shall wait for my turn.
Interim.
Allow, really, he is not available. Not let him not be available.
It was
24
there, your
hours.
lordship, that
No.
that
I have
order
brought
was
to your
there,
lordship
my
kind
lord.
notice the documents.
So correct. The only point. I'm not in merits, but I'm just saying that it doesn't look nice that one fellow is out, the other fellow is in, though both are in the
But
same.
I definitely, that's why I made a submission. I can understand if it were to be a 439 petition. This is a 438 petition.
My lord, still, my lord, liberty.
But if he
apprehension,
wanted
he
to
is
arrest,
away, my lord.
not if CBI wanted to arrest him, we should have arrested him long
He is-
back.
he is
We are at the hands
away.
of this honorable court, therefore we are awaiting. It is not
Let
that not
them,
as
they
well.
undertaking, my lord, they will not take him to custody.
It is not the
They will not
undertaking. I
arrest
am
him.
making a fair submission.
Just the criminal petition 204 of 2026 was moved before this court. The petitioner has sought for being released on anticipatory bail. It is made out from the Adinant Code 204. I was trying to push off. Only bail only. We can't hear days on end for anticipatory bail, days on end. We're not able to take matters where the investigation is stayed.
Not right. I think
No,
this
it's
is
okay.
not in
just
all
saying.
these years. I think this is the second one, my lord, where bail petition we are troubling your lordships.
No, not I'm saying other
I
matters.
definitely no. I can understand the
I've
pressure
spent-
of this honorable court.
No, I spent only on anticipatory bail days on end, days on end. It's gone beyond 482 somewhere else.
But that's why I'm only troubling your lordship only to the point. Nothing else because that voluminous documents we have collected.
No, not your matter, some other matter.
Yeah, I'm not
I can
that-
tell now.
that I know.
Yes. Well, facts that the petitioner was an accused in crime 118 of 2024 and his application for anticipatory bail has been rejected by the trial court. Full stop. In
Crime 78, your lordship, RC 78, my lord. 118, he was arrested, released on bail, my lord. RC 78 bar 2024, 1 EE, E0001, my lord. It is a CBI's reference, FIR reference number, your lordship.
001.
001.
He was an accused in
Rare Karam, my lordship.
para 5.
Yes.
RC number, para 5. Now, this in the 558,
please,
the accused is also an accused in the same RC.
Please. But he had filed showing himself to be legislator, therefore it was assigned. Not
The connected in criminal petition 558 of 2026. The filed by the CBI seeking cancellation of anticipatory bail granted against one of the co-accused. In the same RC, CBI sought for cancellation of anticipatory bail granted by the trial court. Full stop. The trial court in criminal miscellaneous 212 of 2026 had granted bail to the accused B. Nagendra. Senior counsel for the petitioner submits that the present petitioner is also a co-accused in the same complaint. It is noticed that the rejection of anticipatory bail in
Criminal miss 11750.
in criminal miscellaneous 11750 of 2025 was strangely before another court, though it is the stand by both counsels in both matters that both the anticipatory bail applications ought to have been listed before the same court in light of B. Nagendra being an elected representative. Third counsel, Chief P. Prasanna submits that both the criminal petitions hearing will have to be expedited. Full stop. Noticing that both co-accused relate to the same complaint of the CBI, it would be appropriate to decide both the petitions together in order to avoid any form of contradiction. Full stop. The list these matters tomorrow. Full stop. In the interregnum, the respondent CBI not to take any coercive step of arrest. We can pass such a, we don't have to pass a regular interim. Interim we don't have to pass.
Either of them can be done.
Huh?
Either of them can be done.
Till the next date. I'll keep it only date to date. In the next date. Relist tomorrow.
Not my request is not these persons being out, not the witnesses are being threatened. There are certain instances which is there inside this file. Therefore, not my request is not kindly keep it tomorrow. Tomorrow, not without an interim order. Not let that at least let them not repeat whatever they have done or they are doing. That's a request I made.
Otherwise, can you undertake not to arrest?
But that may be difficult, not at my instance now.
Needless to state, it's made clear that if the petitioner were to in any manner act to the prejudice of investigation or try to derail investigation by threat to any witnesses, the protection granted would be subject to revision.
Yes, yes. Oblige. Will instruct. Interim order, my lord. Let's make kindly hand delivery. Oblige.
39. Nice, Chaudhary.
That's for the petitioners in the matters methods. This is a matter methods which methods heard on Saturday methods on the issue of search methods without having taken place and notice being issued under section. Yes, methods. You had sought methods to produce documents. If search has happened, what are the documents they have? That is one thing which was asked by methods, saying that if the search has happened, there should be some document showing that search has happened.
Under the Income Tax Act, if the search is initiated under 132 of the Income Tax Act, he is a searched person. Search essentially, my lord, is qua person and not qua premises. Let me make it very clear. So if the authorities have information.
Just as a information, this order of the bench has attained finality. That he really.
Yes, my lords.
But this particular aspect was not discussed.
Associated
No.
mining. It's not.
Associated mining, yes, we are relying on that. Associated mining, my lord, the matter went up till the apex court, and my lord, the SL became to be dismissed, filed by the SSC. So that is final. There, my lord, the honorable court has made it very clear. It need not be that the jewelry, books of accounts, or the assets have to be, it may be any place where the SSC will be keeping. So the language of 132 is very clear. If the officer has got reason to suspect to believe that the material will be kept, are kept in such and such a place, he can enter into such place, such premises where he suspects that it is being kept. It need not be the place of the SSC in whose place of the person in whose case search is initiated. The word used under 132 is initiation of search in the case of a person. I'll read out the section. It will make very clear.
My lords, before that, my lords, in the same line, my lords may turn to the annexure 1, R1, which they have placed on record. Statement of objection, my lords. My lords may see.
My lord, let my learned friend finish his argument.
No, I will finish my argument
I
then,
don't
my
want to
lords.
go in between.
My lords, that, my lords, what happens is, now, my lords, annexure R1, my lords. That, my lords, would probably get that at page number 9 of the statement of objection. That's, I will point out 3 places, my lords, which may be relevant to this case. First 2 rows of the order, my lords, where the tabular column is there. Name of the SSC. My lords, the address of the SSC. The third one, my lords, is at the bottom under the words assessment order. And I read, my lords, a search and seizure action under section 132 of the IT Act was conducted in the case of measures Kaizen Digital Cable Services under a warrant of authorization on 8/11/2017. As a part of the said search action, the premises, my lords, this is important, as a part of the search action, the premises at FB number so and so, 4th floor, Yeshwantpur, Bangalore, was also searched. It is not there under the warrant under section 132 of the Income Tax Act on 8/11/2017. It is not their case. My lords, now, my lords, with the same breadth, may I request my lords to turn to page number 13.
That premises belongs to?
That premises belongs to one person by name R. Shashikant. Now, my lords, that person was also challenged the notice issued under 153C. And my lords, I have to point out, which was not pointed by the department, which I found out, is that, my lords, that order has been stayed, saying that, my lords, on the same ground, he has taken defense that I would be a search party. My lords, incidentally, my lords only have granted a stay order in that case. I'll give that writ petition number. My lords, R2, page number 13, my lords. My lords, they read out so many things, my lords. At the bottom, they showed the petitioner's name. And in the next page, they showed the address of the person by name Shashikant. Page number 14. And now, my lords, they go on to say, I have searched, admittedly, as per papers, which they cannot produce, my lords, and I have produced on record, is that they have searched one premises which is owned by one person named Shashikant, which is a part of the authorization. There's no difficulty in that.
What is R2?
R2 is the warrant of authorization, which is dated 7th of November 2019. And they say that he was the director of that particular premises, and therefore petitioner, by the extended logic of under 132, I can go do a sweeping search on anybody and everybody. Doing a search on the director would amount to doing a search on the company. At this, last time I'd directed saying that if I could produce some judgment on this point, which has been heard or has been decided by any court, including our court. I was able to find one judgment of Calcutta High Court. Similar.
Now this Shashikant is the director of the company.
Yes, in this case, what has happened is, the issue of 148 was under question. Issuance of notice under 148 was under question. But who was searched is a question which was, one second. My turn to page number 2, without yes. Here, there was it was an organization of a transporting company, On a transporting company, there was a survey which was conducted, which is similar to what has happened in my case. And a search was conducted on the director of the transporter company. And that's juxtaposing two cases, the facts are verbatim similar, Here, what they do, the same, and incidentally, it is for the same assessment year, 1920.
That has no significance.
That's the law at that point of time. Today, 153A is not there. The concept of 153A, is not there. Like 153A, before that there was 158B to BD. After that, there was 153A to 153C, which spoke about the concept of search party and other party, and other aspects. After 2022 June or April, that sections were deleted, and that's why I had to point out saying the relevancy of the assessment here. In this case, what happens is they go on to issue a section 148 notice to a party on whom the survey was conducted. And they go on to issue 153A to a person who was searched. The closest, I could come to my lord's question on the issue, what happens if a party is surveyed and what happens when a party is searched, and both are connected parties. This is my answer to my lords on Calcutta High Court, which is 2025 181 taxman, as recent as 8th December 2025. Tribunal judgment. And if I may rely upon a Bombay tribunal judgment,
What's you first take me to this judgment?
Yes, which paragraph? That's the judgment I was showing to show that, there was a search which was conducted on the director, on whom a notice under 153A was issued, as against a surveyed person, that is a transporting company. 148 notice was issued. That was challenged here because they were trying to add certain other additions, saying that what happens under 148A, if an opinion is taken by the assessing officer for the previous year for the same assessment or same subject matter, that cannot be changed for the purpose of initiating 148A. That was the subject matter, I was only pointing out this judgment to show, the procedure which the department would follow in a similar situation While, my lords, in Karnataka, the officers have decided to follow a different procedure by having an extended interpretation of the word premises. That's at the same thing, my lords, the interpretation of section, that's 132. They are relying upon 132, my lords. If 132 search has been conducted and the words which even they've been relying upon, which has been even decided by our division bench, my lords, in Sunil Sharma's case, which went to Supreme Court, my lords, where delay was condoned, petitioners were heard, that is, the revenue was heard, it was dismissed, they filed a review petition, that also came to be dismissed. There, my lords, they've said the issue of premises does not make any difference when you have actually conducted a search, because you're not conducting a search on a person's simpliciter, you are conducting a search followed by recording a statement under section 132 subclause 4 of the Income Tax Act. Here, my lords, what has happened? The statement which is recorded is of Shashikant. Documents which were seized of Shashikant, which is, my lords, which is a part of my writ petition, my lords, where I have produced the Panchnama starting with page number 20.
Now, what is the subject matter of challenge is as regards?
My lord,
That's 153A notice, my lords. And our contention, my lords, rests on the first point by saying the word initiation, which is referred to in section 153A notice, means and includes that it should have happened. In other words, it should have, the search should have been conducted. Again, my lords, the words which I am making before my lords is the words of the revenue before the Supreme Court, which they took this specific contention to explain the logic and ambit of section 153A, my lords. I can take my lords to the judgment in my list of citations which I have provided, my lords.
Just take me through that relevant provision once again.
My lords, 132 subclause 4 or 153A?
We have to start from 132.
153A, my lords. That's can I, my lords? Notwithstanding anything contained in section 139, section 147, section 148, section 149, 151, and section 153, in a case of a person where a search is initiated under section 132, or books of accounts, other documents, or any assets are requisitioned under section 132A after 31st day of May 2003. As I told brothers, this section was not there before this. Two circumstances under which 153A can be issued is when a search should have happened upon a person, or search should have been initiated upon a person. I'll use the word initiated itself, my lords. The second circumstance is when I requisition documents under section 132A, capital A. But I don't fall under that. They're saying that I'm a search person.
So then you fall back on 132.
Yes, that's when then we fall back on 132. That's the clause 1 starts with certain officers being referred to, where the principal director general, so on, so and so, or joint director or joint commissioner, in consequence of information in his possession, has reason to believe that any person to whom a summon under subsection 1 of 37 of the Income Tax Act, ABC, my lords, I say my lords time, ABC speaks about different circumstances. My lords, the C becomes important for a moment. Because A and B is when, my lords, I try to evade a notice which they think I will be evading if they issue. C, my lords, which is what reliance has been placed on throughout, whether it was under 153C or 153A. Any person is in possession of any money, bullion, jewelry, or other valuable article or thing, and such money, bullion, jewelry, or other valuable article or thing represents either wholly or partly income or property which has not been or would not be disclosed for the purposes of Income Tax Act or this Act hereinafter referred to section 2 as undisclosed income or property. Now, my lords, with this, in fact, this matches with their authorization letter, which is at page number 13. My lords, the next page, my lords, or the next after B, there's A and B, my lords. After then they go on to say the my lords are find that the officer so authorized in all cases. My lords are on that, my lords.
Where is that?
My lords, after I read this word undisclosed income or property, it starts with then.
In C, is it?
No, my lords, above B.
Yes, then.
Then my lords, I would exclude A, I would exclude B because it's not for relevant, my lords. After B, my lords, the words are used are the officer so authorized in all cases. My lords found that in all cases being hereinafter referred to as authorized officer to enter and search any building, place, vessel, vehicle, aircraft where he has reason to suspect that such books of accounts, other documents, money, bullion, jewelry, or other valuable article are or things are kept, break open the lock of any door, box, locker, safe, almirah, or other receptacle for exercising powers under clause I. Search any person who has got out of or is about to get into or is in the building, place, vessel, vehicle, or aircraft if the authorized officer has reason to suspect that such person has secreted about his person any such books of accounts, other documents, money, bullion, jewelry, or other valuable articles or thing. Require any person who is found to be in possession or control of books of account, so on. That's they rely upon and place heavy reliance upon IA, that they can enter any person or they can search any person. That's for that. The argument, my lords, which I'm presenting before my lords is that when a warrant of authorization is issued and a search is conducted, this provision, my lords, serves twofold. Number one, my lords, they believe that, for example, petitioner has kept his documents in a particular place. They enter that premises, take those documents and walk away. Again, that's to the benefit of the revenue. The second circumstance at which it benefits the revenue, why this particular section, it would allow him to enter any premises he has doubt upon, for which, in my respectful submission, my lords, the sine qua non is the original person whom you believe to have kept the documents or stored the documents or have undisclosed income should have been searched. It is in addition to and not in equivalence to. It is in addition to. And this is a precise point, my lords, which was.
So you are saying under 153A, if it is to apply, then the 153 would apply if that person is searched.
Yes, my lords.
That's the
person should be searched. Along with him, let them search anybody they want.
As long as that person is not searched. Question of 153A doesn't apply.
Well, it does not apply.
That's what you're.
Please, my lords, that's my argument. My lords, my argument is also supported, my lords. Of course, my lords asked for another judgment, my lords. Unfortunately, that's the only point of law.
So they are contending, that where a search warrant is issued in the case of a person, it may be to anybody else, because under 132, we can search any other person also.
Please.
And as long as there is a search warrant issued.
Yes.
In the case of the person, whether he searched or not.
153 is applicable is their argument.
That is their
That's in this, my lords, may I request my lords to see the Panchnama, which is very important. Panchnama records an important aspect as who's the person, which is the search location.
Just one minute.
We need all WPS to see. Wait, Ishika, just wait. In my lords, in
just one minute.
Oh yes.
Yes.
My lords, I request my lords to turn to page 20, my lords, of the writ petition. At the same time, my lords, I request my
Now
lords
this,
to keep the section open.
Correct. The definitions, there is no definition of
search party.
Person in the case of a person or one. No.
That's why, my lords, it becomes interesting to see the warrant of authorization, Panchnama. My lords may see the warrant of authorization, my lords, because my lords are seeing the section.
But if you also look at it, a warrant of authorization may be issued with respect to search of A. When they go there, they can search other persons also.
Please, my lords.
Correct, but your contention is that unless you physically search that person, 153A will not operate.
And I say so, my lords, is because of their warrant itself. The warrant itself, if my lords may turn to the respondent statement of objection, page number 13. Because my lords are on 132, I thought this would be apt. That's page 13, my lords. At the bottom is where my name is mentioned. Let's see the paragraph in which my name is mentioned. The Income Tax Act, or under subsection 142 of the Income Tax Act, issued to so and so, to person to cause produce, or under the he would not produce or cause to produce. These two paragraphs relate to ABC. Can compare it with the section itself. There's a logic and reason why, the form has been kept in this particular way. They can't. ABC matches to this.
So the authorization was with respect to
Kaizen Digital Cable Service Limited, where they felt that I would escape, which is what is my
you are saying, if I understand correctly, warrant was initially given for Kaizen.
Yes.
But who was searched was Shashikant.
Shashikant. That aspect, my lords, I would answer to it. If my lords may see in the same, see that the language in the section, the language in the section, my lords, matches ABC. Not, my lords, IIA, but my lords may turn to the next page, page 14, where the address is mentioned, matches to II, IIA, and IIB. which, my lords, only adds credence to my argument, my lords, respectfully, my lords, that it is in addition to and not, my lords, in equivalence to. These are two different people we are talking about.
So though the warrant was for Kaizen, they was of the view that there is something in Shashikant.
And my lords, what happened is, it is not a case, and my lords, one more thing, my lords, procedurally, whether I have to survey a particular party or I have to search a particular party, procedure is the same. So what they do is, with this particular warrant, come to my premises, which I showed, my lords, at the page number 9, which is in a different location, which, my lords, would turn to my writ petition, my lords, where the survey document is there, page number 14. They follow the procedure, get an authorization in my name, which I have no dispute in, which I'm not even contesting, my lords. Authorization is in front of my lords. Use that authorization to survey a particular party, and then, my lords, a search another particular party, which no difficulty. They have done so. They have all the rights to do so. In a similar instance, they issue 148 to a person who surveyed, which is the right position of law. And who does that, my lords? It's not anybody on this side, my lords. It's only the revenue department. In one state, they follow a procedure. In another state, they say no. They go on the interpretation of the word premises, which, my lords, I'm able to convince, my lords, I'm hoping, my lords, that the authorization which I showed to my lords is quite distinct, is ABC, which I showed, my lords, subsection 1. After that, my lords, is in addition to them. He's a foundation. On me, they can start building anybody. They should search me first. After they could have searched anybody. That's the point which was answered, my lords, by the coordinate bench, which was upheld by the division bench, which was dismissed on appeal by the revenue before the Supreme Court. Is that what happens to that party after search is conducted on A, on whom the warrant is issued? You conduct a search even on B, where the address is mentioned. They took a similar argument, or I should say, my lords, the same argument, which has been repetitive, my lords. The court went on to hold, my lords, you have taken a 132(4) statement from them, thereby making them a search party. No, my lords, I am in a situation, going by the division bench judgment. Shashikant has challenged his 153's order. It stayed as of today. The natural course, my lords, would follow the division bench order, like all other searches and all other cases. Today I'll be faced, my lords, I ask myself, with a situation where two people mentioned here get 153A notice, which, my lords, legally cannot be sustained. Using the word premises, my lords, they cannot swindle the game by using it for 153C, or, my lords, and use the same argument repetitively, my lords, at 153A, especially when their warrant of authorization is nothing but a copy paste of the section. And the word which is used in 153A, my lords, two important words, initiation and person. And, my lords, I can show, my lords, my memo of citation, if my lords may. Open my iPad. Give me my iPad. Page 57, my memo of citation, my lords. A question, my lords, rose before. Ultimately, Supreme Court held the position which the Karnataka court upheld, my lords. A situation came up before the court, my lords, where a search is conducted. And after the search is conducted, my lords, the revenue has the authority to open 6 years preceding the search year, which makes it 6 + 1. The question which came was, what can they reopen assessment which is being concluded? Or, my lords, if the assessment is pending somewhere, can they go ahead? Can they go ahead, my lords, and include that in this particular assessment? That's why discussing this, my lords, the revenue, my lords, lost its appeals in Delhi High Court. That was taken to the Supreme Court, my lords. There, my lords, it's a citation quote.
We'll continue, but I'm afraid we'll have it on Tuesday. We'll continue on Tuesday. This is the matter. In the same stage on Tuesday.
I don't know, it's getting listed for orders, my lords.
May I seek for Wednesday, my lord?
Wednesday.
Minutes. 12th
Immediately.
minutes.
Huh?
12th minutes.
On?
Thursday.
It will be on Wednesday.
That's Monday,
We have
minutes.
special court matters. Only Tuesday, Wednesday tax.
11.
That's then.
11th, my lord.
11th.
11th.
That's then can I request it on 18th minutes? Or 17th? 17th.
17th.
Sorry, minutes.
You filed your written submissions.
I will file it minutes.
Both sides.
I don't know about them, minutes.
Both sides to file
Written
their
submissions.
written submissions.
I'll place, my lord. Statement of objections have been filed, but I'll file a small, my lord, submission.
Grateful minutes.
List one, fresh matter serial number 1, Venkata GM. Central tax.
Your lordship,
Yes.
Your lordship, in the present case, we are seeking for the quashing of the rectification order along with the direction to defreeze the petitioner's bank account.
First time, is it?
Yes, your lordship.
I'll take, Lordship may have it next Tuesday. Well, there is a rectification order, the petitioner contends it is after the CIT appeals have passed an order, my lord. So I'll just take instructions why this order was passed. It's a sumo to order by the adjudicating authority himself.
So once the CIT is already passed, then question of rectification.
After the order in original, they went in appeal.
Yes, your
Appellate order was passed. Subsequent to that, the
order
rectification order has been passed.
That may not be permissible is what they're contending.
They are contending.
Yes,
I'll just
sir.
take instruction.
Because it has merged with the appellate order.
Appellate order.
Third Council which one accepts notice for the respondents. List the matter in the same stage on Tuesday.
Please.
2, serial number 2.
Yes.
Lord, apart from the usual ground that the adjudication order covers multiple years, which is not permissible, on merits, if my lords kindly take section 9 of the GST Act, the charging section.
State or central?
Central. The petitioner, my lord, is a goods transport agency. Now, if my lords kindly see section 9, subsection 1. Page 570, we have extracted it, but your lordships may kindly take the book. Section 9. Section 9(1) provides for forward charge mechanism. Basically, the under service, GST is a levy on the service provider or supplier of goods. Kindly see subsection 1, subject to the provisions of subsection 2, there shall be levied a tax called the CGST on all intrastate supplies of goods or both, except on the supply of alcoholic liquor, so and so, on the value determined under section 14 and at such rates not exceeding 20% as may be notified by the government. So there should be a notification by the government to prescribe the rates. That is one. On the recommendations of the council and collected in such manner as may be prescribed and shall be paid by the taxable person. Taxable person is the supplier of services. Now subsection 3 covers a reverse charge mechanism. If my lords kindly see subsection 3, which is an exception to subsection 1 basically, the government may, on the recommendations of the council by notification, specify categories of supply of goods or services or both, the tax on which shall be paid on reverse charge basis by the recipient of such goods or services or both on all the provisions shall apply to such recipient as if he is the person liable to for paying the tax.
So that is reverse
reverse charge mechanism. So one is the normal tax process where it is collected, the tax is to be paid by the supplier of goods or services. 3 is an exception to that, where the charge is on the person receiving the services. Now, once CGST was introduced, notification 13, because subsection 3 requires the government to issue a notification specifying the categories of services or goods on which reverse charge mechanism will apply. Notification number 13 was issued. I'll just pass on, although it's extracted in this thing, the writ petition. If my lords kindly see
13/17,
13/17,
dated 28/6/17.
My lords have that. If my lords kindly turn to page 6.344, kindly see serial number 1, supply of services by a goods transport agency in respect of transport of goods by road to so and so. D is any person registered. Then supplier of service is so and so. Recipient of service can be D. If your lordships kindly see any person registered.
Which serial number is it?
Serial number 1, my lord, at page 6.344.
Item.
My lords have notification number 13/2017.
Supplier of service. This one, same thing.
I'm sorry, maybe notification 11 was given. I'll just pass on. Notification 13 after 17. My lords have the
next page.
Next page. If my lords kindly see the notification also, in exercise of powers conferred under subsection 3 of section 9. So this is the notification that is prescribed under the provision specifying the categories on which reverse charge mechanism will apply. Kindly see serial number 1, supply of services by a goods transport agency in respect of transport of goods by road to. D covers any person registered under the CGST or IGST or the SGST or UGST or so and so. Then supplier of service is goods transport agency. Recipient of service who actually has to pay the tax is, I'll skip A, B, C. Kindly see D, a person registered. Any person registered under any of these acts has to pay the tax. The charge is on that person. Now, as I pointed out, my lord, under subsection 1, the government also has to issue a notification specifying the rates of taxes. So what happened is, when the CGST was, the GST was introduced, first a notification was issued. Small, where is the one page? Where is the first notification?
5/17, Allah. No, all other
notification.
Sir, 11/17 ಇಲ್ಲ ಇದರಲ್ಲಿ. This is a rate ಇದು. Rate notification.
Yes, rate notification.
Okay. This is a rate notification.
Yes. This is the notification which came as soon as GST was introduced, specifying the rates. Now, my lords may kindly turn to page 1.136, serial number 9. My lords have that? Then kindly turn to page 1.137 under column 3, serial number 3. My lords have that? Services of goods transport agency in relation to transportation of goods, including used household goods for personal use. Explanation: goods transport agency means so and so. And kindly see the rate of tax prescribed is 2.5%. CGST, SGST will be 2.5, basically 5%. Provided that credit of input tax charged on goods and services used in supplying the services has not been taken. So input tax credit cannot be taken and the rate of tax is 5%. So when GST was introduced, goods transport agency was categorized or was tax was to be paid by the recipient of service, and the rate of tax was prescribed as 5%, subject to the recipient not taking credit of taxes. Now this 11, notification 11 was amended by notification number 20. Immediately a month later, my lords have that. Is amended notification number 11. Kindly turn to page 6.207. At the footnote 2, my lords have footnote 2. I read the unamended serial number 9 in notification 11 earlier. Kindly see the amended notification, wide notification number 20/2017, dated 22/8/2017. Services of goods transport agency, this remains the same. Then 2.5, provided that credit of input tax should not be taken, 2.5 remains the same. Then a 6%, that is 12% tax is introduced, provided that the goods transport agency opting to pay central tax at 6% under this entry shall henceforth be liable to pay central tax at 6% on all services GTA supplied. So once this was amended, what I did is, wherever, because the charge normally is reverse charge mechanism. The notification under 9.3 was notification 13. The charge is normally on recipient of service. I am the provider of service. So wherever the recipient of service was paying tax at 5%, I did not pay tax. Wherever the recipient of service agreed not to pay tax, or we both agreed that he will not pay the tax, I will pay the tax, I paid the tax at 12% on forward charge mechanism under the amended notification 11.
This is 6%.
This 6 plus 6 plus 6.
Lord,
This CGST, SGST will be another 6.
It only says, my lord,
So we just double it.
Central tax at 6 ಅಂತ ಹೇಳುತ್ತೆ. So there will be an addition of, my lord, another 6%
will
of
be
SGST.
So wherever recipient did not pay tax on reverse charge, I paid tax at 12%.
With ITC.
This continued until 2022. Now 2022, a very significant thing happened. If your lordships kindly take the notification 13. Notification 13 was amended.
My lord, I think, my lord, this 12% with ITC.
Correct, with ITC.
With ITC. That is earlier, it is a 5% without ITC.
How?
I think it is not very clear.
Notification 13, I have read at page number 6.344. Kindly see page 6.345. A proviso was inserted. Now, if your lordship see, the proviso was inserted with effect from 18/7/2022. My lords have that? Provided further that nothing contained in this entry shall apply where the supplier has taken registration under CGST Act 2017 and exercised the option to pay tax on the services of GTA in relation to transportation of goods supplied by him under forward charge, and the supplier has issued a tax invoice to the recipient charging central tax at the so and so. So what happened is, from 2022, the scheme is that there is an exception to the service charge mechanism 9.3 itself, that if I opt to pay under forward charge, then I cannot avail the reverse charge. On all my supplies, reverse charge I cannot pay. I have to necessarily pay on all supplies on forward charge. This came with effect from 2022. Now the period before your lordships is 2018 to 22 until this notification came. Because I paid, because earlier it was only reverse charge, the charge was only reverse charge. Exception was that if I want to pay it at 12%, because the rate notification only was amended, not the reverse charge notification. So I paid on 12%. Now what they say is, for the earlier period, wherever reverse charge your suppliers have paid, there also you have to pay at 12%. That's the issue. Ultimately, taxes have been paid. And more importantly, my lord, how can section 74 be invoked? extended period of limitation, I have paid taxes, either on reverse charge mechanism or on forward charge mechanism. How can section 74, how can it be a suppression or misrepresentation of facts? I have filed returns declaring tax both on forward charge and reverse charge. So on all these points, my lord, these orders have to go. And if the interpretation of the revenue has to be accepted, we have challenged the notification 20 also, that it has to be read down. That's one of our prayers.
20/17.
You're seeking
20
stay of
Stay of annexure B, my lord, is the order in notes.
annexure
B.
ಆಯ್ತಲ್ಲ 6 ವರ್ಷ ಆದ್ಮೇಲೆ ಯಾಕೆ ಚಾಲೆಂಜ್ ಮಾಡಿ?
Ultimately, my lord, according to me, it's revenue neutral because taxes have been paid by the supplier.
no, stay of what?
Annexure
Order in
B is the
original.
order in original.
Page.
Page 87.
The petitioner is summary is B1.
I'm sorry, B27 is the order in original. Those are all because multiple tins were there.
Page.
I'll just point. 135.
Petitioners challenge the order in origin and submits that resort to section 74 could not arise as the petitioner has paid taxes in terms of 9(1).
9(3) and 9(1). I have paid taxes under both.
9(3) and 9(1).
I mean, 9(3) is really by the recipient of the service. I paid taxes on that 9(1).
No, you have paid under 9(1).
Yes.
9(1). ಏನ್ ಬರ್ತಿದ್ದೀರಾ?
ಅಲ್ಲ 2017 notification ಈಗ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲಿ
9(1).
17 notification you are challenging in their
consideration.
If the interpretation
in the interregnum, there will be stay of
annexure B series, my lord, because B order in original is B27, but all the other summaries are B1 to 20.
G1 accepts notice for the respondents. Yes.
Great.
I take notice.
Lordship, serial number 41 of list 2, it was posted for orders. They've been blocking the road, my lord. We heard that my lordship had given the last chance for the petitioner to file his objections. Can we have it day after tomorrow, my lord, please?
Court officer will give dates wherever interim order is still to be considered, wherever interim order is still to be, no, just one minute, that you make a separate mention, those will be taken out of turn, wherever interim orders are not considered. You make a mention to the court office, make a mention to the court officer, adana fresh matters, it's a preliminary hearing, the interim order. Others dates will be given.
If I may.
They have already initiated the recovery, correct, on Thursday or Friday.
No, correct. So I'll take it up. You just no, they have dated.
Serial number 8 you are asking. It is posted second and the stay has been extended, but it has not been recorded and the matter also comes before this day. So the last time you stay extend.
A memo ಅಂತ ಕೊಟ್ಬಿಡಿ.
ಕೊಟ್ಬಿಡ್ತೀನಿ, ಈಗ ಕೊಟ್ಬಿಡ್ತೀನಿ. Serial number 8 sir.
List.
First list. Serial number
Memo
10.
file. Memo file.
Serial number 55 lordship in second list.
Order. Earlier granted is extended till the next date.
Serial number.
List number 2, serial number 42, my lord. After 30 years of accepting even the award.
So you take, correct, you make a mention and take dates, court officer will give.